can't see it. This is very strange.
Audio's on, video is going on in a second.
Video is about to start and audio is on, folks.
And we are recording.
Very good. Thank you. Could you please call the meeting to order?
Adequate notice of this meeting was given in accordance with the Open Public Meetings Act by transmitting the meeting notice to the official newspapers, providing a copy of the agenda to the newspapers, and posting a copy of the agenda at Borough Hall.
Thank you very much. Could I have a roll call, please?
Doherty,
Here.
Herb,
Here.
Howard,
Here.
Meyer,
Here.
Redding, here, Branson,
Here.
Denblicker,
Here.
Eckel.
Here. Approval of the minutes of the regular meeting minutes of April 23rd, 2025. Are there any corrections or comments to the minutes?
I'll make a motion to approve.
Thank you, Jean. Is there a second?
Second.
Thank you, John Demblicker. Got to specify so that we get the right John on there.
Okay.
Are there any further comments? Hearing none, could I have a vote, please?
Doherty,
Yes.
Herb,
Yes.
Howard,
Yes.
Meyer,
Yes.
Redding,
Yes.
Branson,
Abstain.
Denblicker,
Yes.
Eckel.
Yes. Moving on to the public comment portion of the meeting. This is the portion of the meeting where anyone who is here to speak about something not on this evening's agenda would speak. Is there anyone here who would like to speak to the board regarding something not on this evening's agenda? Seeing none, I will close the public comment portion of the meeting and move on to the public hearings. Before we go forward any further, I do want to point out to the board that I am going to be trying to run a very efficient meeting tonight because we have a great deal of things on the agenda to try to get done. And so that we can all get it done while we're still reasonably sharp. I'm going to try to push things forward fairly quickly if we can. So without any further ado, let's move on to, yes, John Demblicker is stepping down on the low application. Careful of the computer cords. Yeah. If you unplug Darlene, it'll be a bad day.
Oh, Steve's plugged in.
Oh, Steve's plugged in. There we go. I knew somebody was plugged in. All right, moving on to Low, Block 12, Lot 3, 24 8th Street. Variance application. This is a continuation of the public hearing. Steve, is there anything I need to do other than what I just said to get this ball rolling?
No, you do not.
All right, very good. The applicant, I see the applicant is here along with her architect. I think you both need to, do they need to stand and be sworn in?
If they were sworn at the last meeting, you remain under oath.
The architect was not sworn. He was not here.
He will have to be sworn. If you could please, sir, stand, raise your right hand. You swear or affirm that the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth, so help you God. Please state your name and spell your last for the record.
Jonathan Perlstein, Perlstein.
Are you being presented as an expert witness this evening?
That's what.
And in what capacity? As an architect and planner, or as just an architect?
Just an architect.
Okay. Can you give the board the benefit of your qualifications?
I've been a licensed architect for too long. I think I got my license back in the 90s sometimes. I had a New York license and I had a New Jersey license. I've been practicing ever since. I've also served on the Historic Preservation Commission in North New Jersey. I've attended several critiques at NJIT as a guest critique for architectural students. But mostly I just like being an architect, just keep doing it.
Have you presented testimony before planning boards and boards of adjustment previously in capacity as an architect?
Yes, I have.
And is your license still in good standing?
Yes, it is.
Does any member of the board have any questions as to this gentleman's qualifications to present testimony as an architect?
No.
Then he may proceed.
Thank you. Will you sit in the front there? Or?
You can stand, sit at the front, whatever you'd like to do there. Just, I think we have,
I think this would help because I haven't before.
all right.
We prepared architecture drawings from Honeywell for this project. It's a very old home that needs to be modernized a bit to adapt to modern living. Being mindful with the additions, not to be too loud or aggressive or having a negative effect on the streetscape. They've been kept as modest as possible. Basically, there are two small additions we're proposing onto the house, a mudroom to the side and a rear entry to the rear and a deck. And we're leaving the rest of the house alone. Putting a new roof on the back, 1 story, it gets better, you viewed the drawings. We've also been asked to prepare the drawings for a small carriage house in the backyard. Sorry. Garage office, call it what you will, it's an accessory structure. It just contains a garage and a small study office, whatever you want to call it, with a powder room. And every effort was made to make this also a modest sized structure. Being mindful of as many setbacks as is reasonable, as well as the height. I know there was an issue before, because it was about 15'3", and we could behind to 15 feet to make it fully compliant. You can see the different drawings to the carriage house, I believe is the remaining issue at hand here because of the issue of the rear setback along the alley. Part of what was done here that was not in the previous application was we indicate how a car can easily maneuver in and out of the garage using the conventional 15-foot turning radius. We set the house, carriage house as far back and as far to the side as possible so as to maximize the yard area for the client. It's not a large lot. The client enjoys the backyard. The green as possible. That is the reason behind the location of this particular structure. The board had asked for a couple of other clarifications on the drawings and the last hearing, which we've taken care of. The most important one, I think, was probably indicating that the walkway to the east of the house is a pervious material. Those impervious coverage has a negative effect on soil absorption and infrastructure, so it's an understandable point. The other issue that came up was, well, the main issue I believe that's still out there is the actual depth of the setback between the carriage house, almost whatever you want to call it, and the alley. But client did was go out there and study the alley, and it's important to note that part of the charm of these alleys in Frenchtown is the variety of setbacks along these alleys. They are not consistent, they meander in out. Some of these structures are shorter than the proposed structure, some of these structures are taller than the proposed structure. But the combination of the setbacks and the varying heights gives a picturesque feel to these alleyways and to the charm of the town. That's basically what we're doing here. Just to satisfy the last remaining questions that the zoning board had when Holly was here last month.
I thank you for the visuals of the alleyway. There were questions about the setback. It was the rear setback, which was the last remaining issue of concern. Steve, at this point, somewhere along the line, since we reopened the public hearing, I should get comments and or questions from the public.
Yeah.
We also have 2 letters that were submitted in support. Now I know I know there's some question about whether or not we can take letters in support, whether or not.
Yeah, usually, letters either in support or in opposition are not to be considered by the board. If there's someone here who can testify to it, the applicant can indicate that they've reached out to the neighbors and they support them, but petitions or any testimony has to be provided in person and not directed to the board in correspondence, because someone in the public may want to question them about that.
Mm-hmm.
Everybody has a right to have a witness prepared, testify, cross-examined if the board or the public wants to raise any questions about what they're submitting to the board.
At this point, would it be best for me to proceed with the board asking questions of the architect and Ms. Lowe, or should we ask the audience?
I think you probably want the board first to
Okay.
ask questions of the architect based upon the testimony that was just presented, and then the board professionals, if they have any questions of the architect, and then open
And
up to the
then open to the
public
public.
for questions only of the architect.
Very good. Does the board have any questions at this time, or?
I have a question. A neighbor last time, expressed some concern about the, being able to maneuver, the driveway. Has that been resolved, discussed? I see the drawing here of the car pulling out, but I can't, translate that into the actual, issue of driving a car either backwards or forwards in the garage.
Yeah, that's a car coming out of the Lowe's property, presumably. This is not addressing the issue of the car from across the alleyway.
Across the alleyway.
We heard testimony, well, we had a
From an
comment.
concern about turning radius.
Turn-
on adjacent property, right?
Yeah, because them trying to get out of their own property on the other side of the alleyway. But yes, I think this illustration is showing a car coming out of the Lowe's garage
Yeah.
and turning
And
onto
then
the alley.
Go in the same way.
Yeah.
Well, the alleyways are 15 foot right of ways, and you know, typically when you have a double loaded parking lot, it's 50 foot high, that's 18, 24, and 18. For car to pull out, you need 24 feet behind it, which you don't have now. And you wouldn't have unless this carriage house was pulled 10 feet into the property, maybe, you know. But that would be unusual for this alley because all the other structures, are, like I said before, they're arranged in various ways along the alleyway, and I'm not too sure if this particular design makes anything any worse than it is now. I mean, it's just, I think people have grown to accept that it's a narrow alleyway and they have to proceed with caution to use it.
I guess the question does, yeah, please.
I spoke with the property owner earlier this evening, and invited him to the alley to show him how so he has a garage that's directly opposite our existing shed.
Mhm.
And I explained to him how that existing shed can now be gone and there will be parking there. So in fact, if he was backing out of the garage directly opposite it, which we've never seen a vehicle parked in that garage, but if he were to back out of it, he would now have more space because he will have a parking spot to utilize. Because the structure we're putting is further from his property. And I explained this to him and he was pleasantly surprised, and I'm saying this like, you know, into my testimony, he was surprised. It seemed he didn't understand the drawings, even though he said he looked at them. And he said, oh, this sounds good, thank you. So
Yep.
that was the conversation I had with him this evening.
Great, so yeah, in effect, there will be more space, not less, right? Right,
He would have to encroach on Holly's property to exit, right?
correct. Thanks.
Which I would gladly grant him, should he need. We typically don't park in our alley like most numbered streets. We park along the street because it's easier access to our home. So we don't envision having a car there.
Understood, thanks.
Other questions?
Yeah, I have a few questions. So on drawing A8, okay. That's this one here. Okay. This shows the measurement. And then others. Let me know when you've got it in front of you.
Yeah.
Okay. So the drawing in the lower right corner labeled the site study of setbacks of existing structures along alley. These are measurements in inches of the distance from the edge of the structure to the edge of the alley gravel. Right, okay. So the two structures below the number 3, so 24 is your house, right?
Yes,
And then there's the number 3 on that, and then below that are the two structures that are on the property right now. One of which is the shed that you're talking about, which is gonna be removed, right?
Correct. One marked 72 inches.
Well, they're both marked 72 inches. Is that one
The
structure?
one on the right.
Yeah,
The one on our property, marked 72 inches within the number 3 lot.
yeah.
It's gonna be removed. Correct.
What about the one so that's the smaller of the two?
Right.
What about the one that Jason showed that's larger?
That belongs to the Lewises on the Harrison Street property directly to us.
That's-
We're right next to each other.
Right, so that's part of 708.
Correct.
Is it actually across the property line? That's the way it looks here, if I'm reading it correctly, or?
Oh, there's a whole lot of houses in Frenchtown, outbuildings,
Yeah.
that straddle property lines.
Okay,
Yeah.
yeah, so, going back to this other drawing, but this drawing A1 depicts a fence on the west side of the property. And shed there from the Lewis property, is that, I mean, not that it needs to be show that per se, but is that fence going to go right up against the Lewis shed? Then you're looking at drawing, I'm looking at drawing A1,
The one right, this right here?
proposed view from the north, yeah,
To clarify.
sorry, from the south,
I see where you're going with this. The thing is, that map on A2,
yeah,
it's like a Google map, you can use this directly.
on
And
page
it's
2,
not as
okay,
accurate- Yeah, it's not as accurate as the survey on A2.
yeah,
If you look at the survey on A2, the neighbor's shed is clear of the property, but it doesn't conform. So I would
Okay.
think the fence would end at the northeastern corner of that shed. If you know, there's for a fence beyond that. Because the shed is right on the property line.
the Lewis shed is on the property.
According to the
Okay. So the map that's on A8 is something off Google? Okay,
Yeah.
got it. So it's
Sort
not,
of surveying of the lot.
Right. yeah, I understand. It's not intended to show the actual dimensions of lots of building. Okay, so each one of these are the distance from the alley gravel. What is the alley gravel? I know what it is, like physically you're measuring where the gravel is, but in terms of the survey, is it, where is that, what is that distance from?
Is it the edge of the rut? Or, it's sort of measuring
Well-
to the edge of the gravel I don't know what that is.
Yeah, there's.
I agree with him.
There's net property line on the survey, there's. A number of indicators, I'm just trying to get a sense of how that relates to,
The survey is the closest thing we have to something that's accurate, even though it's not informed. And even on the survey, you can see that the actual right of way of the alley encroaches on the alley property and the neighbor's property. So the alley is obviously not, a professional surveyor, but just
Sure.
want to get a certain range of setbacks.
okay,
And that's really the intent of that. It wasn't meant to be a precise thing.
I
It's just meant to show that there's a variety of things going on in that alley.
but I understand. So the alley that you're talking about on, A2, in the upper left corner, which shows the new additions and structures.
Yeah, the upper right has the proposed.
Yep.
Yeah, upper left is the existing.
The alley's depicted on the bottom by the kind of crosshatch line that's running east-west. There's one on over each other. That's the alley.
It's,
Okay, all right.
that's the legal alley, but it's, in reality, it encroaches on the properties too.
Yeah, understood. Understood. So is it your testimony that the gravel area corresponds at least roughly to the area shown as the right of way on this drawing on A2?
I think that's fair to say.
Okay,
I mean, again, it's not a clean line, there's no curve or anything, it's
I
a
understand.
meandering thing.
So the drawing you're referring to is the survey by Stan Norkovich,
correct.
just to be clear for the minutes. This is not-
The
this is
one
not-
dated 2012, John, is that the one?
Yes,
Yeah.
Yes, July 28, 2012. So, so when you're, asking for relief from the requirement, what is our setback requirement? It's 5 feet from
5 feet from the property line,
the property line. Okay,
which is not the same as the ground.
Right.
I understand. Is the property line the net property line that's shown on the survey? Or is that?
Well, on the survey, the net and the gross are the same to the back.
Okay.
So we would use that imaginary legal line.
So,
So they're asking 5 is as of right and the request is for something less than that.
yeah, what is the request we're getting? Is it 2 feet or?
2 feet.
I wanted to clarify a little bit that the actual property line is not a mysterious imaginary line. It is a
Right.
legal definition of the property line. It is not,
Go there, you can't really know where it is.
Oh,
you can't do that on most people's
Yeah,
properties.
well,
but that's the line that you'd want to use.
Yes, I understand. I just wanted to clarify that it is not an
Yeah.
imaginary line.
so the net property line refers to the fact that part of the property is occupied by the alley. Alright. So what I'm gonna try to get a sense of is, okay, so you've measured these distances, you're 72 inches from the gravel. How far would your building be set back from the gravel? If you use the gravel as a benchmark relative to other structures, is it also 72 inches or something different? Do you know?
I don't know what the measurement is when you look at A2, the drawing on the top right. This indicates 2 feet, quarter inch. As the net property line.
As the distance between the property line and the proposed building. Because your testimony prior to this was that you were talking 1 foot 9 3/4 inches
Off the legal.
off the property line.
So I guess if you take the 72 inches from the, because the question was from the gravel, and you add 2 and
Well,
a quarter.
what I'm trying to get a sense of really is, given what you're asking for, how would it compare to these other structures? Can you testify, would it be about 72 inches or something else? Because you testified that, there's a sort of irregular pattern back there and some stuff's already not, near the property line. I'm just trying to get a sense of how this would, what this would.
From our point of view on the proposed, plot plan, the intent is that it lines up with the house.
Be about 72 inches, in other words.
Same setback.
Okay.
I have a question.
Yes, if we could go to Brad here.
Okay, so if I'm looking at Holly and I was gonna A1. And I'm looking at the photo of A1.
You're on drawing A1?
If I
Okay,
look
thank you.
proposed view from south, it's at the bottom of the page.
Yep.
Where that parking pad is now, that would be the location of what would potentially be the former shed that you have now, right? And the wood pile, so that goes away. So if I look at that structure to the right. Is the edge of that proposed carriage house structure at the current, is it parallel with the existing shed would have been? It's just you're shifting theoretically the shed over.
It's no closer.
So
to
it's
the
no
alley.
further in, no further out. You're keeping the existing line that was there,
That's how we-
which is kind of similar within line with like Lewis's property to your left. Okay.
Yes, they would all be similar.
Okay. So,
Because right now you're aligned with Lewis's property.
The shed,
Right?
I mean.
What's that?
The current shed.
The current
Current
shed,
shed.
aligned with Lewis's
So-
lot, if I recall from the photo.
Right. So if I can summarize to be clear, the question is that our ordinance gives a rear yard setback of 5 feet from the property line, not the gravel, not anything else, but from the property line. Your previous testimony was that the new shed, the garage and office or carriage house, whatever you want to call it, is going to be 1 foot 9 3/4 inches away from the property line, which will be exactly in line with where the existing shed is. So it's going to be the same distance from the property line. What you're proposing will be the same distance from the property line. Because really where the edge of the gravel is immaterial. It's going to be the same distance from the property line as the existing shed that you're going to demolish.
Yes.
Does that clarify?
Yeah, and if I
Okay.
can just follow up, so I understand on drawing A8 again. The photographs that are shown in the upper part view. A valley facing northeast and northwest, is the wood pile, is that yours?
Yes,
Okay, and the building right behind it is the shed that's gonna be removed,
yes,
and the white garage to the left in the view of alley facing northwest, that's the
Lewis's.
Lewis's
Yes.
garage, okay. So the fence shown in, A1 view from the south would be coming down, basically, eventually adjacent to the Lewis garage.
yes.
Right, we should terminate it early.
Oh, before the garage,
Okay, basically be in line. with
Yeah, yeah.
the Side of the wall.
okay,
Great.
Great. okay, thanks. So, yeah, to reiterate the point, I think the chairman made, the new structure would be in line with the existing shed. Okay,
All right,
thank you.
very good. Are there any other questions?
Just a clarification from my reading of the plans, the rear yard setback would be 2 feet 1/4 inches. The side yard setback for that structure would be 1 feet 9 3/4 inches.
According to Darlene Green's memo,
Depends on what plan you're looking at.
okay, let Darlene speak.
I'm looking at the plans, this is actually something I was gonna ask, because if you're looking at sheet 8.7, there's a dimension that, I have to zoom back in. I can't do this now. Yes, 8.7. There's a dimension on the west side elevation of carriage house that shows 1 foot 11.5 inches, which doesn't comport with the prior plans that showed 1 foot 9 inches. And then I don't know what sheet you're looking at, Steve.
Which, yeah, you're looking at Stan Norkovich's plan.
Right.
That,
Just
if
don't
I
know.
may, one,
Let's see, this one here.
Yeah, so the Stan Norkovich plan does say it's 2 foot 1 inch. But A7, I see that now, and I had missed that before.
Right, so we need to know
It's
what.
1 foot 11.5, and your previous testimony was 1 foot 9 3/4 inches. So we're gonna have to come to some sort of an agreement exactly what you're asking for.
I have to apologize, it is a drafting error. Because I guess the plan that we should go with, I would respectfully request to go with the floor plan. That shows 2 foot 0.25 as the side yard setback, and 1 foot 9 3/4 is the rear yard setback. Why it says 1 foot 11 and change on the west side elevation, I don't know, but it shouldn't say that.
1 foot 9 3/4 it is, which is what the previous testimony was.
That's what the request is.
Yes.
I'm sorry about that.
So that's
So I see the 2 feet and 1/4 inch on A7.
But they're clarifying it. He's told us it's 1 foot 9 3/4.
1 foot 9 3/4 rear yard setback,
That's rear yard
2
setback.
foot 0 and
Rear yard.
2 1/4 is the side yard.
2 0 and 1/4.
It's
Well,
the side.
I'm not sure, wrong.
just the rear.
Yeah.
Okay,
Yeah,
yeah, let's have them give us the testimony for that because I thought I had it straight and now I am confused.
I agree.
Yeah, it's
So the backyard setback. What is it?
9 3/4,
And the side yard setback for that shed would be
2 0 1/4.
is the side yard setback
2 0 1/4
Yep.
is the side setback to
for the carriage house.
the east.
Are there any other questions for the architect at this time, or the applicant?
The only reasoning I heard for the rear yard setback was to maximize the area of the backyard.
Right.
For the client. Is there any other basis of granting the variance other than to maximize the area of the rear yard for the client?
Well, we could argue that.
Recognizing you haven't been qualified as a planner, and you're only presenting architectural testimony.
I went to Columbia for planning and I hated it, so I never did anything with it.
No, I guess you can't provide that testimony.
I can't, I'm not qualified. Because when I got out of Syracuse, there was no work for architects in 1977, so I'm like, well, what do I do now? I never did much with it, that's what happened. But the further away, this carriage house is from the main house, just more green space between the house and the garage. And once you start getting, if you start pulling it towards the house, you're gonna have more of an area between this garage and the alley that you have to figure out what to do with it. I mean, you could theoretically landscape something that's more deeper, but I'm not too sure how sustainable it is,
But we're talking 4 feet
Yeah,
difference from.
yeah.
3 feet.
Yeah,
If I may,
actually
it's
less.
square feet, so if we were to do the 5-foot setback from the property line, we're losing 69 square feet in our backyard, which to me is a garden bed that I could have, and have space for in addition to all of our other uses of our backyard. So it's significant space that can be utilized for something else, whereas in the alley, it's lost space that really can't be used for much.
There's a standard of proof
I
for
understand
a
that.
C variance. And, I'll give the board the standard of proof for a C variance. That's the testimony that's been raised in support of the C variance. And at the appropriate time, if you want, we'll give you what the criteria is.
So your point is, however much we might want to grant this, we do need to stay within what is specifically allowed.
I'm not saying that, I'm saying that the board has to hear the testimony in support of the variance, either it's a C1 variance or a C2 variance, and I can give you the criteria for that, and it's the applicant's burden of proof to provide testimony in support of the variance that meets that criteria. You're the one who's gonna have to weigh whether they've satisfied that criteria.
The chair would be appropriate for Ms. Lowe to talk to that at all?
Yes, I think it would be appropriate for Ms. Lowe to attempt to address that
Sure.
at this time.
If you
Um,
want, I can tell you what the criteria is to help.
Let's do
to-
that. Let's do that. Let's give a little guidance
So.
so we can
um,
move this forward.
I'm gonna get real legal on you and actually quote the statute. Look out. So in terms of a C1 variance, it has to be shown that by reason of exceptional narrowness, or the conditions uniquely affecting the property or the shape of a piece of property, or by reason of exceptional topographical conditions, or the physical features uniquely affecting a specific piece of property, or by reason of an extraordinary and exceptional situation uniquely affecting a specific piece of property, or the structures lawfully existing thereon, the strict application of the ordinance would result in a peculiar and exceptional practical difficulties and or hardship upon the applicant. That's a C1 variance. It's known as the hardship variance. There's also what's known as the flexible C variance, which is a C2, and it's where the applicant can prove that a specific piece of property deviates from the zoning ordinance and that the benefits of the deviation would outweigh any detriments granting of the variance would cause, provided, that's it. In either event, they have to prove that the variance can be granted without a substantial detriment to the public good and won't substantially impair the intent and purpose of the zone plan and zoning ordinance.
So if she were to argue, for example, that this isn't gonna interfere with anyone getting in or out of their garages, that it's not significantly different from what's there right now, and that because her yard is so narrow, it is unusually narrow, that going with the full 5-foot setback would produce a yard that's just sort of much smaller than the other similar yards in Frenchtown, that's a large harm.
And with a hardship.
Hardship.
And with following along, and the addition of said by granting the C2 waiver, that 70 square feet, 69 square feet of extra green space is beneficial to the community and all that, that it would otherwise be.
Well, still be potentially green space, it'd just be on the other side of the, so it would be beneficial to the community, be beneficial to them.
Seeing what accumulates from those green
Right.
spaces.
No, I know exactly what accumulates there, actually, better than you think.
It's actually whether the proposal presents a better zoning alternative than what's required under the ordinance, under the C2 variance. And that's usually provided by expert testimony
Okay.
by a planner. The hardship variance is a little bit more leeway for a board to find that a hardship variance can be granted by the way of factual testimony, because you can take into consideration the unique factors affecting a particular lot without expert testimony. But getting into a C2 variance, often you require a planning testimony. Some boards don't, but
Thank you for clarifying.
you're welcome.
So
Thank you
maybe
very
we
much.
should let Holly talk.
Yes.
And Steve, stop talking.
Well, I mean. I mean, it is tricky not being an expert to comment on all of this, but I mean, I do think. We discussed, the fact that it is a substandard irregular lot. We do have a uniquely large tree. We considered adding onto our property at the rear of the house. We don't want to lose the large tree. This is the way we can get what we need to continue to live in our home and retain as much use of our backyard as possible. But I agree with everything that Ted pointed out. I mean, I think that this is more your role or a professional planner's role, but I believe that the 5-foot setback from the property line is a detriment to the look and feel of our alleys, and I feel like that's what we're asking you to reconsider. Like, do we really want all of our alleys to have?
I think you want to talk about your property, not general alleyways. You need to focus on your hardship and your property.
Throwing it all at the wall and whatever sticks, I would appreciate it, if that's what you consider. But yes, if our structure is further into our backyard, I think it takes away from the unique look of our property and our part of the alleyway.
Tell the large tree you're talking about, where is that located, and would it be required to be removed if it's?
No.
Okay.
So the addition that the mudroom, we went through this quite a bit
Yeah.
last time. The large tree that they're talking about is actually fairly much closer to where they're doing the construction for the mudroom.
Okay.
So arguing that the moving the shed would be a
Impact
problem for
that
the
tree.
tree is a little bit problematic, since they're already doing construction much closer to the mudroom.
We have ways of working with trees in terms of foundation design to help.
Right.
Understood.
So I guess.
But I could also say that the closer this little carriage house is to the alley, the less shadow it casts on neighboring properties as well, because it is to the south of the house. And the closer you bring these little structures to the alley, especially since you're not bringing it any closer to the alley than the adjacent
Right.
structure, you're actually not only benefiting Holly Low, but you're benefiting the neighbors.
It's an interesting point.
So clarification from council, the C1 is less problematic for us to decide on than the C2?
Well, it's less problematic from the standpoint that you can take the testimony of the fact witnesses, and you have to get into whether the benefits outweigh the detriments in terms of the zone plan and reviewing the zoning ordinance. Usually that's done by way of an expert planner. But you can still find a C2 if you wanted, if you feel like you have enough expertise to be able to make those decisions. But C1 is usually without a planner presenting testimony, something that people try to hang their hat on.
Perhaps it would be appropriate this time to hear from the public. Let's see if we have any comments from the public.
Want comments or just questions first, or you want to do it all at once? Usually it's just first questions.
Let's do
And-
questions, and then we'll do comments.
Right.
All right. Do we have any questions for the applicant or her architect from the public this evening?
Any questions of the testimony that you just heard?
Well,
You just have to identify yourself, sir.
I'm sorry, yes. Joe Mundy, we live across the street from the Lowe's, sort of, catty corner. So we're not anywhere nearly affected by that at all. But we took a survey of survey, but we looked back there ourselves. And
So the question, you have to ask a question, and later on I'll swear you in to testify, but now would be the time to ask them a question about their
Well, I
testimony.
guess since I don't fully understand the whole problem of of why it makes such a difference that the proposed structure is going to be in the same plane as the existing structure. I guess that's what I really don't understand. So my question is, why is that such a problem?
You would be asking them that question. I think they would agree with you.
I'm sure.
Yeah, so now's your time to ask them questions about their testimony. Later on, I'll swear you in, you can testify.
Okay.
Okay? Yes, sir. I'm sorry.
Yes, sir. Stand and state your name, please.
My question is, do you think that,
Please state your name, please.
it's Armin's on Merodia, the 47.
Thank you, Armin.
Do you think it enhances or preserves the look of the alley? Do you think that having a new freshly built building there that's in the same place as a previous building was, is gonna make the alley look more attractive and reinforce the character of it?
Yeah, I do actually, because it enhances the mix of structures. You go up and down the alley and it's, you have a lot of structures that have no windows and no doors. Then all of a sudden you have one like starting night kind of brings life to the alley. And as I had mentioned before, it's not going to be the biggest building on any alley, it's somewhere in the middle. So I think what it does is it does its share in making an eclectic effort to fit in a nice way in that alley scape.
And I would add, the existing shed is a prefab 1990s, I think, shed. Whereas we are looking to build a structure that we designed carefully to fit the look and feel of the historic homes and the historic garages along the alley. So I think it will improve the look of both our property and the alley.
Thank you. Are there any other questions for the applicant and her architect at this time?
And that would be appropriate to ask them whether they have any other testimony or witnesses that they want to present, and if not, open it up to the public.
Any other testimony you folks want to present? Okay,
Then you would open up to the public to provide comment or testimony or evidence to the board.
anyone who'd like to provide comment or testimony or evidence at this time? And you're going to have to state your name again.
Armin's Merodia again.
And I'm gonna have to swear you in.
Okay.
Will you please raise your right hand? Do you swear or affirm the testimony you're about to give before this board be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Thank you for the response to my question. It sounds like it would enhance the alley, so I would like to express my support for the proposed addition. I own a house that was built before 1970, and like probably everyone else who has one that was built before 1970 in Frenchtown, we have a non-conforming accessory building. And if your house was built after 1970, I'd say probably a 90% chance you'll also have a non-conforming accessory building on your property. And I don't think it's a detriment, like the alleys are defined by the fact that they are filled with non-conforming structures. And putting something back where it was, in my mind, will preserve that rather than having a jog in the alley in order to conform with the setback that did not exist when that structure was built. So I look forward to looking down the alley and seeing it built.
Thank you. Are there any further comments or testimony? Yes, please stand and state your name.
Name's Christine Money.
Would you please raise your right hand? Do you swear or affirm the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
So Holly was nice enough to take us back and explain in detail what they were going to do, how this shed was gonna go away, and the big one is gonna be over here, not a shed, more than a shed. And we could not imagine how it would make any difference to anyone. And this has been actually very informative, because I realized we have quite a non-conforming building that's just right up against the alley. And I just support it, because I just can't see how it could, you know, be a detriment to anyone. And also, I would like to see a young family like Holly's stay in the area. I see her children playing, and she's been involved in the town, and apparently they're going to have to move if they can't, you know, add more space to their home this way. That's all I have.
Thank you. Any further testimony or comments from the audience? Hearing none, we will, do we close the,
Entertain a motion to close the public portion of this hearing.
I'll move it.
thank you, Jean, is there a second? Thank you, Martin. Do we vote on that?
Yes.
Yes, could I have a vote, please?
Doherty,
Yes.
Herb,
Yes.
Howard,
Yes.
Meyer,
Yes.
Rennie,
Yes.
Branson,
Yes.
Stenberger,
Ken Blicker stepped down.
Eckel.
Yes. All right, now we debate the finer points of this and decide what we're going to do, if I'm not mistaken, correct?
That is correct. I already gave you the standard proof for the two, for the C variances. I can repeat them again if you want. The variances are identified in Ms. Green's report and as clarified on the record this evening, and any condition would include of approval would be compliance with their two reports of both of Mr. Clerico and Ms. Green, as well as just look at our notes here from the last meeting. They already revised the plan to have the walkway comprised of permeable material.
And the height issue.
And they should fix the height issue.
Written confirmation from licensed arborists as to the potential impact of structure placed further from rear of the lot line.
I think we've let that go at this.
Yes.
Okay. He takes good notes. That's all I have. In terms of, other than the standard conditions.
Well, I would suggest that, if we're looking at a hardship variance, there is a reasonable argument. We already, I believe, made our mind up about all the rest of the setbacks at the last meeting. So we're really only looking at the backyard setback. And I actually found the testimony that, that the 3-foot distance would in fact be 69 square foot difference in a small backyard in Frenchtown. And the testimony that this will be perfectly in line, and presumably, the testimony from Ms. Lowe that her neighbor, who was concerned about the turning radius coming out of their garage last time, has now presumably, she had this conversation with him. She's testified that he was pleasantly surprised, and he didn't show up this evening to reiterate the problem with the turning radius. So that has been clarified. It's not technically a pre-existing condition because they're not putting back in the exact same place, but they're sliding it to the side. I think that perhaps the case has been made fairly reasonably.
I agree. I agree, Randy. I think what I would add to your observations was, for me also this evening, the images were very helpful.
Yeah, the images were very
And
helpful.
also
So we could picture
the
this.
other one that was helpful was the one where I can see the current shed in relationship to the Lewis garage.
Yes, yes, because that was really impossible for us to evaluate the any of the criteria of this application without having those visuals and seeing exactly what we were talking about in the back alleyway there.
So we are proposing a motion to vote approve.
Well, we're discussing it right now.
We're discussing at
We're
this
discussing
point.
it.
Is there other? Yeah, we're getting there. We're getting there quickly.
I have a question. So I wanted to clarify what the applicant has asked for. Have they asked for a C1 or a C2 or?
They've asked for C variances, and they can add, you can make a finding either as to a C1 or a C2 or both. If you think, there was some testimony that was presented with respect to aesthetics, and that by making this an improvement, that's better than the condition that there's now, and that there's a benefit to the public by improving it, and that might be considered a C2, that the benefits outweigh any
Right.
detriments to the rear yard setback not being followed. So there had been testimony that arguably could support a C2 variance in addition to the C1.
I thought the C2 made sense from the sense that the applicant's attorney and the applicant testified to the fact that the
Architect.
architecture, rebuild of the structure will be kind of keeping it the theme of the alleyway, to have a more pleasant look, and it was kept in mind with what the other outbuildings look like along that alley structure, including several historic small barns.
Yes.
With a slight improvement.
That would be consistent with a C2.
Yes,
Yeah,
because that would be. I'm failing.
Benefits outweighing-
Benefits outweighing the detriments. Thank you. I knew the planner and the attorney, one of them would be able to come up with the right word there.
Even though we don't have testimony of a professional that you might normally expect around a C2, we can,
I think you can make that finding.
we can make that finding as a board, okay?
Right, so, and the variances that they're requesting were outlined in Darlene Green's memo of March 3rd.
So we can move to grant a C2 waiver? We can make
Well,
that
we need a
motion?
motion, but. I
It's
think
not a waiver, it's a variance.
You're
Sorry.
arguing, you were talking about the C1 component, so is it a C1 and a C2?
You
Yeah.
tell me that and I can make that the basis, because I've heard comments from board members articulating both reasons.
I think that what we heard tonight does make it relevant to both.
Yeah, it does.
I agree.
I agree.
Yeah.
I agree. So Steve, can you give us a sort of an outline what that motion might look like?
Would be a motion to approve the variances as identified in the Green's report and as applied for, both on the basis of a C1 hardship and a C2 benefits outweigh the detriments, subject to the conditions I identified, including compliance with the two reports that will mark B1 and B2, and all other standard conditions of approval.
I'm prepared to make the motion.
Thank you. Is there a second? We'll give it to Ted. He was muffled, but I think he can reach out there.
And you said we marked them B as in boy 1 and B as in boy 2?
Meaning board 1 and board 2.
Okay, thank you.
Right. If there's no further discussion of the motion, could we have a vote, please?
Property,
Yes,
Herb,
Yes,
Howard,
Yes.
Meyer,
Yes.
Redding,
Yes.
Branson,
Yeah.
Eckel.
Yes. Thank you very much.
Thank you.
I didn't hear you on that. That's okay.
Yes, we're back, when people wear masks, we're back to COVID times where we can't hear where they said. Right, thank you. Moving on to the housing element and fair share spending plan public hearing. I am going to our attorney and our planner on how we,
This hearing was properly noticed, and what we should do is swear Ms. Green in to provide
John Denblicker's coming back.
and provide sworn testimony as to the plan that's being considered by the board this evening for possible adoption. And the board has a draft resolution of approval that has been prepared by the borough attorney.
Very good. So at this point, we swear in Darlene and
Do you swear or affirm the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Darlene, it's your show.
Sure. So before we dive into the plan, I thought it was important because I was hoping we'd have some public to give a little bit of background because affordable housing is a convoluted topic in the state of New Jersey. So it all started back in 1975 when the New Jersey Supreme Court ruled that every town in the state of New Jersey has a constitutional obligation to provide a realistic opportunity for the construction of affordable housing. Now that's a mouthful. What it really translates to is that towns don't have to build affordable housing. They have to put the zoning in place or the mechanisms in place to create the opportunity for the housing to be built. Unfortunately, they didn't give any guidance on how to do that. So there were a boatload, that's my word, of lawsuits following that. And the state quickly realized that this was a problem. So it took them until 1985 to enact the Fair Housing Act, which provided an administrative process for communities to elect to participate in. To oversee this process, the Fair Housing Act created the Council on Affordable Housing, or COA. They were in charge of adopting regulations and promulgating affordable housing obligations, and everything started to move along swimmingly. The first round of affordable housing started in 1987 and it ran until 1993. It was a 6-year period. After that, then there was a second round of affordable housing obligations issued in 1993, and that ran until 1999. COA then realized that 6 years was not enough time for them to issue obligations, towns to prepare plans, and then actually have builders build these buildings. So they said, let's stretch it out and we'll make them 10-year rounds. So the third round was supposed to run from 1999 to 2019. However, COA tried many times to adopt new regulations, but none of their regulations could withstand judicial scrutiny. And so after many failed attempts, there were more lawsuits, and in 2015, the Supreme Court stripped COA of their power to review plans and returned the review of affordable housing compliance back to the courts. So we rewound back to the 70s. Towns were then ordered in March of 2015 that in order to comply with their constitutional obligation, they had to submit a declaratory judgment action by the summer of 2015. If they did not do so by that deadline, they would then be open to a build-a-remedy lawsuit. This followed COA's process, which was a carrot and a stick approach. COA always said, if you voluntarily comply, we will give you protection from build-a-remedy lawsuit. That was the carrot. The stick was build-a-remedy lawsuit. In that context, someone who either owns property or is a contract purchaser can sue a town saying town X is not complying with their constitutional mandate to provide affordable housing, and I, Mr. Developer, I'm a nice guy, and I will build the affordable housing along with its market rate housing. They go to the county judge. The county judge has the ability to erase your zoning, to erase your master plan, and award the remedy. That's the stick. You lose all control. So the 2015 Supreme Court order maintained the carrot and the stick approach. Frenchtown, like many other towns, filed a declaratory judgment action in July of 2015. We wound our way through that process, and ultimately you ended up with a judgment of repose and compliance. In that process, you had a prior round obligation, which comprises the first and the second round obligation of 2. And your third round obligation was determined to be 52. So those 2 numbers have been set in stone for quite some time. We then fast forward to last year in March, when the governor signed legislation that dramatically impacts or modifies the state's affordable housing regulations. It was a short 75-page bill known as A4 that abolishes the Council on Affordable Housing, even though they had already been stripped of their power in 2015. It modifies the process of affordable housing compliance. It amends the bonus credits, and among other changes, it sets forth several important deadlines, part of the reason that we're sitting here tonight. The amended Fair Housing Act charged the Department of Community Affairs with the preparation of the new obligation. That includes your rehab obligation and your 4th round obligation. The DCA did that. They issued it in the fall. They've assigned the state of New Jersey a total of over 84,000 new affordable housing units for this round. That number is then distributed down to the 6 affordable housing regions and then distributed to the towns through an average of 3 factors: equalized non-residential valuation, income capacity, and land capacity. We reviewed the DCA report. We found no glaring errors with it, so we accepted the numbers that they gave us in that report. The rehabilitation obligation for Frenchtown is 11, and the 4th round obligation is 22. We accepted those numbers in January. They were set in stone, I think, sometime in March when we received the order from the court. As I mentioned, the Amended Fair Housing Act sets forth certain deadlines. The next important date that we and every other town in the state of New Jersey has to meet is June 30th. By that date, towns have to file a new housing element and fair share plan. Failure to meet this deadline results in automatic loss of immunity. That has never occurred before in the 1st, 2nd, or 3rd round. Before, someone had to drag you into court and sue you and go through all the motions. Now it's automatic. July 1st, you lose immunity. So it continues the carrot and stick approach. So the housing plan that we have due in 32 days must address the four obligations: rehabilitation 11, prior round 2, third round 52, and fourth round 22. So that is the background. So if you have your handy dandy housing plan, I will go through it, sort of page by page. And I will tell you there is a spelling error on page 3 in the table. I will fix that if the board approves it. So starting on page 5. Under the affordable housing rules, towns are allowed to seek adjustments. So if you have a lack of sewer, if you have a lack of water, if you have a lack of developable land, you can submit information to the program, that's who, the program, the Affordable Housing Resolution Dispute Program has replaced COA. I don't know what their acronym is going to be. So the program will be the one reviewing the housing plans. So as you are all very well aware, Frenchtown does not have a plethora of vacant and developable land. We have vacant lots, no doubt. There's a reason they're vacant. They have a flood hazard area, or they have wetlands or a stream encroachment. And so the vacant land adjustment process first looks at the environmental constraints in the borough. Then it overlays on top of that land use, specifically looking at Class 1 vacant properties, 3B farmland, and 15C public properties that are vacant and do not have any sort of restriction, whether it's an open space restriction, a conservation easement, and the like. We overlay those two, and then we look at properties that could yield could build at least 5 units. Because under the affordable housing rules, once you get to 5 units, that's what triggers an affordable housing unit. You may recall that from when we had the application a couple of months ago for the 2-unit complex, we could not require an affordable housing set aside because they hadn't reached 5. So reviewing all the parcels in Frenchtown, what we have learned is that there are no lots that are within the sewer and the water service area that are vacant and developable and meet the minimum lot size of 0.625 acres. There are lots that are larger, but they are either outside of the water service area or the sewer service area. And without those utilities, you cannot construct multifamily housing. So that essentially results in what is known as a realistic development potential of 0. In the world of affordable housing, you have to satisfy your realistic development potential, what is known as your RDP, and you have to address the difference between your RDP and your obligation, which is called unmet need. They sound similar, but the satisfy part, we'd have to actually put zoning in place, make sure those mechanisms come to fruition, you don't ever have to do the total of your unmet need. That's not a requirement. You put a few mechanisms against it and call it a day.
Darlene, could you, for clarification purposes, also note the 0.125 acres issue of being not considered adequate, even though there are many areas of that size?
Yes, so the process looks at not only properties that could produce 5 or more units, it also then breaks the properties down into categories of environmentally constrained, infill, which would be something that could accommodate a single family home, or undersized. And so the density that is commonly used across the state in evaluating a vacant land adjustment is 8 units to the acre. So in order to get 5 units on a property, you would need at least 0.625 acres to generate 5 units. To have 1 unit, assuming a density of 8 units to the acre, that's where you get the 0.125. So while there may very well be lots in Frenchtown that are smaller than 0.125 acres, in this analysis, that's the trigger because we're using a density of 8 units to the acre. Anything less than that, it is considered undersized. It doesn't affect our zoning, it doesn't change our master plan, it's just the analysis, the way the exercise operates.
Great, and again, to clarify, is this correct that there is no prohibition against building units or having units at 0.125 acres? That's in a sense the policy, not a rule.
It's not a rule. It doesn't affect our zoning. It's just that's just the way this vacant land analysis works for making sure that we're categorizing all of the properties, because even though it might not meet the 0.625 acres, we still have to, for each one of those vacant lots, say why it is not included in the analysis. What's the reason? Environmental constraints, undersized, infill, etc. So then the next large portion of the report is the housing element. This section on page 9 explains all of the required components. That's pursuant to the amended Fair Housing Act, not something that Darlene made up. After that, there are a lot of demographic data. Some of it you may find interesting. If there's anything that you think is inaccurate, I will tell you this is what comes from the census and the American Community Survey. And some of my towns, they say, Darlene, what do you mean? They say there's a 20-unit building in town. I don't know where that came from. I can just tell you that this is their data and we're required to report on these topics. They have no bearing on our obligation, no bearing on our mechanisms. It's just what's required.
They're really pretty interesting.
Some of them are. If you skip forward to page 26, this chapter is dealing with projection of housing stock. We are also mandated to get out our crystal ball and try to estimate what will be built in the borough over the next 10 years, which is a little difficult. We use historic data to help with those projections. So you'll see on page 26, we pull data for over 10 years on the rate of COs and demolition permits that have been issued. And the only reason you're at 69 COs is because of Harrison Square over the past 11 plus or minus years, and Milford and 8th Street. Shouldn't forget that. So then if you go to the next page, you'll see the projection of overall residential development. This includes properties that are either under construction today with building permits or sites that this board has approved but have not yet received their building permits. And then all of our future projected affordable housing sites. I have picked years. I have no idea when these sites will come to fruition. I have to assign them dates. So I just selected dates. So that's that section. Then we turn to the capacity section on page 29. So we have to look at land capacity, which we've already done via the vacant land analysis. We know that you don't have any large properties that are both vacant and developable in a water and sewer service area. We also have to look at utility capacities, which that data was obtained from the 2 purveyors. We have to identify appropriate locations for affordable housing. There is nothing new in this plan that isn't already zoned for today. I have to list any potential developers that have submitted letters or concept plans. Luckily in Frenchtown, no one has bothered you. In other towns, there's a laundry list of potential suitors. And then we have to talk about anticipated development patterns. Chapter 8 is a new requirement, has no bearing on the housing plan. It's just a requirement. Chapter 9 is also another requirement where you have to talk about consistency with the state plan. However, the state plan hasn't yet been adopted, so it's a little difficult to compare it for consistency when we don't really know what the final report will be. This now turns to the fair share plan. This is where I have to the rubber meets the road. This tells us I have a spelling error once again on the same table on page 36. I will fix that. I will at the end talk about regional income limits because I think it's important for the board and the public to understand that the folks that move into affordable housing have to have an income. Not only is there a ceiling, but there's actually a floor for them to qualify for these units. And I have the brand new 2025 regional income limits with me. So flipping to page 38, we begin the discussion of the mechanisms and the credits that we have today to allocate against these 4 obligations. We don't have any rehab credits yet, but that's also because we couldn't create them if we wanted to. You can't get a rehab credit until you're actually in the round. The round does not begin until July 1st. So even if we did a rehab today, it would not count. So it's impossible to have existing rehab credits. We do not have any existing prior round credits, but we do have existing mechanisms that we can credit towards the 3rd round. First, we have the DeSapio senior apartments. Up there, we have 3 affordable units. We get 3 credits for that site. Then we have the former ceramics plant, which is now known as Harrison Square. That development contains 17 affordable units. And because under the 3rd round rules, you could get what they call rental bonuses. We get 10 bonus credits. So that site gives us 27 credits, which is huge. Last but not least, we have the 8th and Milford site. There's 1 affordable housing unit there. We get 1 credit. So at the top of page 40, you'll see that right now today, we have a total of 21 credits 10 bonuses for a total of 31 credits that we are attributing to the third round obligation. Then we say, okay, now what are our proposed mechanisms to meet the remaining obligations? And so we discussed the rehab obligation a little bit last month. So we are proposing 3 mechanisms to address our 11-unit rehabilitation obligation. Rehabilitation is different from all the other obligations. It resets like Groundhog Day every 10 years. So whether you did a great job or whether you did a poor job, doesn't matter. You get a new number in 10 years. Rehab is where you take existing homes in the borough, and if those residents are income qualified, you fix one or more major systems: roof, HVAC, electric, plumbing, well, septic issues, those sorts of things, and you bring the home up to code. The idea is that you're essentially renovating the existing housing stock for those of lower income who wouldn't otherwise have enough money to fix their roof, to repair their plumbing and the like. So the first program that we're going to do is a very standard program that towns across the state do. It's a borough-sponsored rehabilitation program. We are setting aside money in the Affordable Housing Trust Fund. That is a fund that was created many years ago. It receives funds when development happens within the community, and it bears interest. And so we have to actually use that money on affordable housing. We can't use it for the general fund or for parks. It has to be used for affordable housing. So we're earmarking $30,000 of our trust fund for this rehab program to do 3 homes with the borough-sponsored program. Then we're also going to rely upon the county housing rehabilitation program. When towns did their third round housing plan, the county actually did not have a county-sponsored program. So this is a wonderful program because 1, it doesn't use the borough's trust fund. 2, it still helps borough residents. And so what we will do is advertise that program through the website, through whatever mechanisms Sam tells me we have, to alert folks to this program so that they could take advantage of that as well. We're hoping that, anywhere from 4 to however many more homeowners want to take advantage of that program that they do, because it's available to them today as we sit here. And last but not least, this is actually my favorite one, is what is called Elder Cottage Housing Opportunities, ECHO. This is a mechanism that is, think of it as an accessory apartment, a tiny home. Some people would call it like a mother-in-law suite, but it's detached from a single family home. So it is a self-contained unit. It's erected on a site that already has an existing house, and it is restricted to individuals that are 55 years or older or folks with disabilities. The rules state, and these are the prior round rules, so they are very old and antiquated, that the borough has to actually purchase the ECHO units and move them around every 10 years. We are actually asking for a waiver from that because the borough is not in the business of purchasing tiny homes and moving them around town. Furthermore, it's a little concerning because if someone did opt into this program, and let's say they moved their elderly in-laws in their 60s into that tiny home, and then the borough 10 years later said, so sorry, we have to move your tiny home, you'd have to evict your now 70-year-old in-laws. That doesn't seem wise or like good planning. So we're asking for a waiver from owning the ECHO units and moving them around town. Instead, what we propose to do is create permanent accessory apartments that would stay on the lot after the 10-year deed restriction is over. So whether it's an elderly couple or a disabled person, they could live there as long as the primary homeowner wanted them to stay in that home. The rules do require that there be a 10-year deed restriction, that the occupants are affordable housing, meet the income requirements. But what is wonderful about this program is that you do not have to affirmatively market it. It is the only affordable housing mechanism where you're not required to market it to the entire region. So you can hand select your tenants as long as they income qualify. So this is what makes it great, because someone who has a set of elderly parents could move them in and let them live their life out, adjacent to them, but have their independence. This would create housing stock that we've talked about at the board for a long time, how we want to make Frenchtown a place where people can age in place and create unique opportunities. And I think this really checks a lot of the general plan box that we've talked about for several years here. The borough will once again use that trust fund and give each one up to 4 homes or homeowners $5,000 towards the construction of that accessory apartment, whether it's a modular that they bring in or it's stick built. The ordinance that's in draft format that's attached in the appendix would allow these units in the R1 zone where existing single-family homes are located. The lot would need to meet the minimum lot size standards and the other bulk requirements for setbacks and the like. So we are anticipating 4 units to be created through that program. So that's rehab. Prior round, there was one mechanism allocated to it in your 3rd round plan. That's the River Mills site. The board is very familiar with it. It's been granted several approvals over the years. The latest approval that was granted had 4 affordable units in the mixed-use building on Bridge Street. And because they generated a fraction of an affordable housing obligation, there's a payment in lieu that they would have to give us. While we are all well aware that construction is not commenced on that mixed-use building, it is my understanding that there are folks looking at that site. The the zoning is in place, the approvals are in place. All we are waiting for is a developer to start construction. So when that happens, that site on page 43 will have 1 credit and 1 bonus allocated to the prior round, as well as 3 credits and 3 bonuses allocated to the 3rd round. So we get a total of 8 credits out of that site when it is built. Next, we have the R8B zone. I'm on page 45, which is south of, it was in the 3rd round housing plan. It was called south of Ceramics. Because I guess it's everybody knew where that was. So these are 3 properties that are between access off of 6 and 7. These sites are already zoned today for inclusionary housing development at a density of 14 units to the acre, 20 and a 15 or 20% set aside, depending on the tenure of the units. Those sites have not yet developed. Also, there are some DEP encroachments on the properties, which with the changing DEP rules, I don't know what the future of these sites look like, but for now, what we're proposing, because they would have to elevate the first floor of living area because of the DEP regulations, we're proposing to increase the density to 20 units to the acre. Over all 3 sites, that only changes the total yield from 24 to 34. So I don't want anyone to get scared thinking, oh my goodness, we're giving away the store. This is really a modest increase to try and incentivize the redevelopment of those 3 sites. If all 3 sites were redeveloped at the maximum, if they were redeveloped, the 3rd round housing plan had assumed 4 credits for these sites. I maintain that even though we are increasing the density. I didn't want to get ahead of ourselves and start over promising and potentially under delivering.
Well, I think with the DEP flood hazard stuff there, we shouldn't over promise anything on that site.
I would agree. And there may be a point, depending on what happens with the Gene, am I right? Real regulations, is that what the acronym is? We may have to revisit this
Yeah,
site.
because it's my understanding, it's not just the property, it's our roadways leading in that become an issue.
Right, so if you don't have high and dry access, then you will not be able to build multifamily housing. So this data was pulled from DEP that's on our mapping. But I know that, things are changing. It's a rapidly changing environment. So we may have to revisit this site in the future, but for now, it is zoned. It's been in your 3rd round housing plan. It was approved by the court in the 3rd round. We're going to maintain that. Then on page 47, we have actually next door to us, the church/daycare site. This property is already zoned today for inclusionary development. However, the way the zoning ordinance is written, it says that both those structures have to be maintained and renovated. They cannot be demolished and rebuilt. And so once again, we have a site that hasn't come to fruition. So what is attached to this document is to have a modest density increase from 10 units to 14 units and to allow for the single family home to be demolished. keep the church, that would remain, they'd have to renovate that, but they could demolish the single family home and repurpose that. So it gives a potential redeveloper a little bit more flexibility, because right now they're very handcuffed in that they'd have to fit everything inside those two buildings as they exist.
Well, I mean, and this is from experience of the home we actually lived in, but the definition of renovation in the state of New Jersey is quite broad. And I know there are buildings that have been declared as renovated when one wall was retained, the entire structure wiped out. One wall remains, you go, oh, that's not new construction, that's that qualifies as a renovation. So, you know, in a sense, it can be, there's a possibility of it no different from new construction, even though, you know, technically it's renovation because we left 7 bricks in place.
Right, I would tell you that the ordinance actually says that neither building can be demolished. That's the way it's written right now.
So again, depending, if you leave a wall standing, is it then not demolished?
That's where the building
Right.
inspector would come in, and the construction department, no doubt.
Right.
Mhm. So that site was earmarked for 2 credits. Then we flip to the next page and we have the R3 zone expansion. So this is along Route 29 in the southern end of the borough along Trenton Avenue. The council actually rezoned this back in 2017 to the R3 zone, which previously just encompassed the garden apartments. Now the single family homes along that stretch have also been rezoned to R3. One of the things in reviewing the ordinance that I discovered is that right now the minimum lot size is high. Oh, so I want to reduce the minimum lot size to 30,000 square feet. So part of the problem is, I shouldn't say problem. I think I understand, if I was channeling my inner Betsy, I'm pretty sure what she was trying to do, Betsy McKenzie was the prior planner. What she was trying to do was encourage someone to go and accumulate a bunch of the
I think so.
homes and then have a little bit bigger of a development, which is what all of us would love. Unfortunately, nothing has happened in the past 8 years. And so we can't necessarily force people to work together. So instead, I thought, looking at the average property size, let's bring that down. There's still nothing precluding someone from assembling multiple properties, but this may open up the door if there's one person that is looking to sell and transform their property, that they then wouldn't be penalized coming here for a variance from that minimum lot size. The density would stay the same, the yield would stay the same. So we had assumed that we were getting 8 units if all of those sites were eventually redeveloped.
Yes.
So that it's important to note that there were 2 other sites in your prior court approved plan. The first was Shale Cliff, which is at 4 Kingwood Avenue. That is where Kathy's is. So that site received preliminary site plan approval all the way back in 2009, only preliminary. Since 2009, as everyone around this table is well aware, there have been a boatload of regulatory changes. And if you look at the map on page 53, you will see this poor site is covered by some environmental constraint on every inch of the property. The most concerning of which is the flood hazard area. It encompasses the overwhelming majority of the property, except for the upper right-hand corner where the parking area is. So having reviewed the mapping, I knew this was going to be an issue. And so Mr. Cruz, the borough attorney, reached out to the property owner, Mr. Pearlstein, and we actually have an email from him because we were concerned, knowing that his prior board approvals have expired, that the DEP regulations have changed, the flood hazard area has grown across his property. We asked him, are you still inclined to attempt to build an inclusionary development? And you'll see on page 51, he said that he is disinclined to proceed with the Shale Cliff. That's what it was. That was what it was called.
That was what it was called.
The project was called Shale Cliff and it was inclusionary development. He's disinclined to proceed with the Shale Cliff project at this point in time. So because we have a property owner who says they're not going to build an inclusionary housing development, we have DEP regulations that would severely constrain the construction of multifamily housing. That site no longer meets the four-prong test under the affordable housing rules of approvable, suitable, developable, and available. And in that third paragraph down, I wrote approvable twice. It should be available, so that needs to be fixed. So it doesn't meet those four prongs. So therefore, it does not present a realistic opportunity and provide credits. So we need to remove that from our plan. And typically, you'd say, okay, fine, we'll just substitute in another site. But we are a vacant land constrained town. So there is a case in the affordable housing world called Cherry Hill. It is where there's a changed circumstance. So, these housing plans are done at a point in time. And in the future, someone could come into a town and say, oh, look, I now have a 10-acre site. This was actually, I believe, a racetrack, which was larger than 10 acres. They said, we're not going to use it as a racetrack anymore. Instead, we're going to build inclusionary housing development on this racetrack. And the town was a vacant land adjustment town. So before, the town had said, oh, our vacant land adjustment is very, very tiny. But now all of a sudden, this land that was not vacant is now available. And so they have to reanalyze their vacant land adjustment. So the Cherry Hill case works in the reverse, which Randy told me I have used the word reserve as opposed to reverse. So I need to fix that in that paragraph too, which is a good catch. And so it works in the opposite. So if you have a site that as of the third round housing plan, we thought was available, suitable, approvable, and developable. We had a willing property owner who was going to pursue that. So we put it in the plan. And now, fast forward 8 years later, we now know that we don't have those same conditions. So that site needs to be removed from the housing plan. And because we're seeking a vacant land adjustment, it actually needs to, we need to do a vacant land adjustment to the third round obligation, not just the fourth round obligation, but the third round obligation. So this would actually decrease the third round obligation from 52 to 50. I know. So then we move over to block 48, lot 7. This was the application we had a couple of months ago at 69 Kingwood Avenue. So this is similar circumstance. Here, in this instance, we had an unmapped tributary that has a 300-foot buffer. It was not mapped on anything. I went back, I looked at the maps that Betsy had prepared. That stream was not shown on any map. So it just, no one knew about it. So of course, fast forward, there is now a mapped tributary. It has a 300-foot buffer. As the applicant presented to the board, they can only build a maximum of 2 units in the outer 150. They cannot build the townhome development that is permitted on in the R8E zone. And so this site was earmarked for 3 credits. So once again, we have a reverse Cherry Hill situation where we need to deduct that from our housing plan. And that would drop third round from 50 to an RDP of 47. So that's third round. Now we go to fourth round. So we have an RDP of 0 for the fourth round. So we have to satisfy 0 credits. Easy. The amended Fair Housing Act, though, added a new requirement because it wasn't hard enough to satisfy 4 obligations. There's one more that they've added. So there's now a new requirement to provide to identify sufficient parcels likely to redevelop during the current round of obligations to address at least 25% of the prospective need obligation that has been adjusted and adopt realistic zoning for that. Now, there are already multiple interpretations of what that mathematical formula is, but I can tell you, we talked about it at the subcommittee level, and this is the same stance I am taking in all of my towns. Adjusted obligation is synonymous with RDP. So 25% of 0 is 0. We are not doing any zoning for this new aspirational redevelopment requirement. However, on page 50, no, there's a lot of math. 7, you will see that there is one mechanism that exists today that I have allocated towards the unmet need for the fourth round, and that's the Frenchtown Village Center plan. Today, we allow mixed-use development in the Frenchtown Village Center plan. We allow residential uses above commercial uses. We have a set aside today in that plan of 15 and 20% depending on tenure. So that was not in your third round housing plan. So no one knew about that. even though it existed back then. So we are essentially notifying them of something that has existed for several years. The one thing that I have recommended is that we increase the set aside to 20% in the village center plan. And that is because historically, rental developments received a bonus credit in the prior round and the third round. They have eliminated the rental bonus credit. So before, you could say to an apartment builder, it's okay, give us 15% because we're gonna make up the difference between the 15% and the 20% with your rental bonuses. Because the bonuses have been eliminated, there's now no value in giving them a lesser set aside. So that's why, and a lot of my towns are doing this, 20% across the board, no matter what tenure of unit you're building. So that ordinance is attached to the appendix. So if you go to the grand summary, which is on page 60, you will see all of the existing and the proposed credits. The 3 programs for rehabilitation. River Mills is our only prior round mechanism. Then we have and then for third round, we've got DeSapio, Harrison Square, 8th and Milford, River Mills, R8B, R8D, R3, and then for fourth round, we have Frenchtown Village Center Plan. So those are all of the mechanisms. As I said at the beginning, nothing is new. No new sites have been identified. It's just a matter of making some minor adjustments to some of our existing zoning to make sure that these zones are viable. Then you would have there's also an implementation schedule. That's where I also have to use my crystal ball to say when all of these things will happen. And then lastly, you would have received a separate PDF with the appendix. That's 123 pages of light reading. There are deed restrictions attached to that. So this essentially substantiates all of the credits we're claiming. So everything that's been done, we attach the deed restrictions to prove that they're creditworthy. In addition, the vacant land adjustment documents are attached. There are several other requirements such as a spending plan, which is the purview of the governing body, and intent to bond resolution, municipal housing liaison resolutions, a lot of the other nitty-gritty details that actually go into effectuating the units when they are constructed. So that's the summary. Happy to take questions or comments.
Well, you take a breath for a second. I want to first thank you for all the work you've done.
Thank you.
But I also want to thank the committees that led up to this, because we had a committee, and I didn't look up what year we formed it, but we had a planning board committee that was Jean and John and Paul and Manette and Darlene. I think that's all of you that put together an enormous report where we started thinking about a lot of these things and ways that we could make this work. And then that transitioned to a borough committee, which was with council. So then we had Brad and John Demblicker again, and Michelle, chairman of council, and John Doherty and Darlene again, that went through the last machinations on this. So it's been a long time and a lot of people working toward an intelligent plan. You know, Frenchtown has always been ahead of the game and making sure that we have been up to date on our obligations so that we avoid builder's remedy while we seek to provide affordable housing opportunities in the borough of Frenchtown. We're not just doing it just to keep out of trouble. We're actually doing it so that we can provide affordable housing. And this was wonderful. And your walkthrough of it was fabulous. So I wanted to say that before we got to any questions, because and I figured you needed to breathe for a moment there. So
Thank you.
I'm usually good to talk for a couple of minutes and let people take a breath. So does anybody have any questions?
I just want to also compliment Darlene and the group for all their work. I think it's a good document, and I think it was a very difficult document to prepare with the
Oh, I think so.
deadlines.
Oh, the
I like
deadlines were crazy.
I like the combination of leveraging county funding along with our own,
Mhm.
trying to get stuff done. And I think the Echo units are very innovative and a new approach to housing in Frenchtown.
I really like the plan.
Mhm.
I really do. Questions?
There had been talk a long time ago, but I suspect it's been dropped, of requiring municipalities to have to include in their plan consideration of potential impact on adjacent municipalities. So that's not a requirement.
Oh, I think, Jean, you're thinking about, trying to think about which master plan document that might be. That might be the land use
Maybe
element.
transportation.
I mean, transportation would make a
circulation.
lot logical sense. You
Okay,
should.
not this one.
Not this,
Okay.
believe it or not, no, and it's funny because when you look at certain towns' housing plans, all of their affordable housing.
Are
is
on the
edge,
border.
And there's
Yes.
nothing that precludes it.
Right. I'm assuming that in your first sentence that you mean to say the New Jersey Fair Housing Act.
As opposed to just
The
above fair
federal-
housing.
The federal one. Right? According to the Fair Housing Act.
Oh, yeah, I can add New Jersey.
Right,
That's
right.
not a problem.
But I guess, so my question is, does a New Jersey municipality have any obligation under the federal law?
To prepare a housing plan,
Or in general, I guess?
not under the federal law to
Okay.
prepare a housing plan.
Okay. And then just kind of in the spirit of Randy's comments about how the borough is sort of ahead of the game, I thought in terms of the affordable housing history, since this document is something that will be poured over by residents for decades to come, whether it might make sense to mention that the plan was developed with input from a variety of committees so that it reflects the sort of deliberative nature of its development. So just a thought.
I think we could leave that up to Darlene to
Okay.
cobble together a sentence that said something like that, if she wanted to throw that in.
I mean, I guess I'm kind of.
In the introduction?
Take credit.
Oh,
where
I was
credit's
actually gonna
due.
put it under the page after the cover page. Special thanks.
Thank you.
Because we did have a lot of people that worked.
Yeah.
Toward this
Yeah,
and
and I guess-
bounced a lot of ideas.
And
around.
years from now, when there's a different members on this board, it'd be good for them to know.
Yes.
I'd like to go to the appendices, because, you know.
Let
they're-
Darlene finish
they're-
writing her sentence and then we'll go to the appendices.
I didn't open that yet, so just give me one second.
It's all the way at M,
M,
not just for Marty, but, you know, and, appendix M.
magnificent.
Well, gee, thanks. You call Marty.
All right. Just bear with the Wi-Fi law.
Yeah, it's on the,
I'd let you stare at my
Revenue
paper
and
copy, but I'm.
expenditures.
sure you'll
Spending
enjoy
plan,
it.
okay.
spending plan.
Mhm.
I'm just looking at the total expenditures of just short of $160,000
Mhm.
with 23,500 as admin expense. That's more than 14% of the spend is to administer the rest of the spend. That seems like a rather high amount of money to, you know, $23,000 to manage $150,000 seems like a lot.
No,
It's,
It's
Looks like they're-
actually cheap. So I would tell you the borough rehab program,
Mhm.
whether it's a municipally sponsored rehab program is tremendously expensive. There are some firms that actually charge you more than the cost of the rehab is. We are capped at 20% of what we collect over the lifetime of the fund. And so 20% is so funny. I'm like, trying to get there. Ah, here we go.
What table are you looking at? What page?
Appendix M.
appendix M, page 6.
Page 6 of 8, administrative
Mhm.
expense calculation.
Right, I'm looking at the expenditures.
And that's that's 21,000 over 10 years
Mhm.
as well, so
No,
we're,
but it is, again, it's more than 14% of the expenses to manage those expenses. That just seems from a rather high figure.
So we're allowed to do 20%. I will tell you that the rehab program is expensive. And also the borough has to have on retainer an administrative agent for its general operations.
Mhm.
That is also not cheap. I have no idea what your
that's where we
contract
spend
is.
the majority of our money.
No doubt.
Affirmative marketing of the properties.
Correct. So they handle all any general inquiries go through them. They handle, when Harrison Square, for example, was under construction. Harrison Square has to pay them to do all their marketing, income qualify the residents. But we have a separate contract for all of our general administrative agent duties. We are mandated to have an administrative agent. That's just a requirement under the statute.
Do other towns also have administrative agents?
You're required.
They're required to.
Right.
So
And
it's figured
so,
out units.
no, I'm just wondering if we, well, like if we shared an administrative agent.
So that's, I will tell you, there are essentially 4 firms in the northern half of the state that do the AA work. You have to be certified, so they've got the corner on the market. I wish there were more, because now that towns are actually being forced to implement affordable housing, 4 is not enough firms. It's becoming quite difficult
Right.
to get these projects moving because of the shortage of staff members that these 4 firms have.
Right. I don't want to take too much time, but if we had, 3 municipalities together negotiating with those 4 companies, we might be able to get a price then as a single, one.
So here's the problem. The price is partially based on how many units you have on the books. So it varies, town by town where you go.
Mhm.
So, for example, I represent someone else in Hunterdon County who right now has no units on the ground. So their price would be completely different than yours, where you got however many units on the ground currently. It also varies depending on what your affordability assistance programs are in your spending plan. So some affordability assistance programs are very expensive for the AA to implement. So the problem is, because every town's plan is so unique and different, it would be hard to package together, because the services that we require, the next town over may not require those same services, or may require more services. It has not been set up to be efficient. This is the way the statute is.
But one of the things certainly moving forward is if the borough could find a way in 2 years or 5 years or 6 years where this becomes more intelligent, are there other firms? We would certainly look into that and investigate that.
Mhm.
But right now, this is our best estimation. You're telling us that this is actually much more cost effective than what some municipalities as a
Well,
percentage
and
go.
below what we're mandated.
And well below what we're mandated, because you said we're mandated to spend no more than 20% more.
Well, part of the problem is I shouldn't say problem, you've already spent some of that money. So
Yes.
you have to remember, this spending plan is a snapshot in time. So it looks back at all of the expenditures and income since the inception of your trust fund, and then projects forward 10 years. So it's retrospective and prospective, which is a little difficult to do at the same time.
And one of the challenges, I think, of partnering on affordable housing with some of our surrounding communities is Frenchtown's approach to it, and some of our neighboring communities in Hunterdon are radically different when it comes
Yes.
to affordable housing.
Yes.
I mean, I had a local official say to me that they wanted to see all their affordable housing put on Frenchtown's board.
Right.
Because we're the most uniquely situated to handle those type of people, since we
Although,
Did they-
we have a grocery store and other
Right.
things.
yeah, but my understanding is, and Darlene, mentioned this about the variance, that, the 2025 numbers, that, a couple or two people, earning as much as $96,000 a year, qualify for affordable housing. So we're not exactly talking
Well,
about
it's
people who can't afford it.
It's a gross misunderstanding of what affordable housing is, so a lot of people intertwine that with section 8.
Right,
and
right.
they use them
Section 8,
interchangeably.
right, subsidized
Yeah.
housing.
Not just actually
Right.
past. That's it.
Yeah, we got it.
Yeah.
Yeah, there's.
While we're doing questions.
Oops. I got an extra one.
Type is too big.
Did you have more to go over? No. Did you, does anyone else on the board have questions? Because we do
No,
need
thank
to
you.
open up to the public somewhere along the line here for questions. Do we start with,
This isn't a public hearing for purposes of an application for development, so you can take.
do comments and questions all at once?
Right.
All right.
And I can swear people in as they come.
As they come up. All right. So let's open up the public hearing portion. Is there anyone here who would like to speak to the board, has any questions for the board, or has any comments for the board regarding the affordable housing plan? Please stand and state your name for the record.
Arden Dumbaroti. Would it make more sense to do all the comment or the questions first? So
You
that
can do it all,
address
you
those?
could all do it all at once. Let me just swear you in.
Okay,
You swear affirm the testimony you're about to give before this board will be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
Thank you.
so my first question is, would it make sense to do all the questions?
However you want to proceed, you could ask questions and then testify, whatever you want to do. Now's your time to speak on it or ask questions.
Gotcha. The RDP was calculated as 0 in the report, and my understanding was that that can also apply to non-vacant parcels. Is that correct?
That can also apply to no, the vacant land adjustment only looks at 3 classes of properties, class 1 vacant, 3B farmland, which I guess could have a barn on it, and 15C public property that does not have a structure.
Well, I'm saying aside from the vacant land assessment, is the RDP, it only takes in the vacant land into the realistic development potential? Just for example, like with Harrison Square, that was not a vacant parcel when it was included in earlier planning.
Okay, so I think what you're doing is, so you're, I think, confusing mechanisms with RDP. So we have we get an obligation, which is 22 for this round, and then we can seek adjustments, whether it's for sewer, water, or for a lack of vacant and developable land. So the vacant and developable land is a snapshot in time. It was done with 2024 parcel data, and that looks at those 3 categories. So that says how many properties are in Frenchtown, and the map is attached in the appendix, shows where all those 3 property types are, and then goes through why they either they're undersized, environmentally constrained, infill, et cetera, or outside of the sewer and the water service areas. Goes through all the reasons, either why they can't be developed for inclusionary development, or what the limiting factor is. Then once we get an RDP, that's then when you apply all of your credits.
So the RDP is separate from the vacant land assessment, essentially in terms of.
The RDP is what you end up at the end. So that RDP is your realistic development potential. And in Frenchtown, we have a 0 unit realistic development potential because we have 0 properties that meet the 0.625 vacant and developable acres.
So I guess my question is, like, looking back retrospectively at properties that were occupied that didn't meet those criteria, they wouldn't have appeared on a vacant land assessment, but they ended up being the source of affordable housing units in the 3rd round. So how did, if they had been analyzed under an RDP, would they have also been counted as 0?
So the borough did not do a vacant land adjustment in the 3rd round. It did not seek any adjustments of its obligation in the 3rd round. So I was not the planner then, so I don't know. I don't know what the process was in the 3rd round.
Yeah, because I guess what I'm alluding to is, like, it seems like the opportunities in Frenchtown are largely like in redeveloping parcels versus like things that are already occupied. So that ends up excluding stuff that actually is like the majority of, the sources.
It's like 6th and 7th Street and right, basically they're existing structures that can be
They are.
demoed.
Right,
So it's.
And that's why we
redeveloped.
rezoned them.
Yeah.
yeah.
I mean, that's really what we're left with in the town because of all the environmental constraints. And we're running out of commercial and industrial areas to rezone.
Yeah, and if the stuff down by the towpath is not accessible because of flood hazard, that's a major part of the remaining balance. Just again, thank you so much for preparing all this. I do have a really long list of questions, but I'm gonna try to be concise about it.
Do try to be, because they still have other things on the agenda as well.
Sure, we own a property that's on the vacant land adjustment, and it's listed as having water but not sewer. In fact, it's the reverse, it has sewer, but it does not have water. It's block 45, lot 2.
45 lot 2,
Yeah,
and you say, I'm sorry, you have,
we have sewer there, but we do not have water. And on the vacant land assessment, it says that we have water and not sewer.
well, that's interesting because I can tell you that map came from the state of New Jersey.
Yeah, so I can show you the cleanouts. If you want. But
I'm not sure
anyway,
what to do with that.
and then another question I had before getting to some of the comments is, how is the payment in lieu calculation arrived at? $240,000 per unit?
That is based on the 2008 COA fee, 3% overtime.
So that's like, that calculated differently from municipality for like land values or?
No, so I would tell you, all of my Hunterdon County towns will have a payment in lieu of 240,000.
Wow.
You won't build an affordable housing unit and the land. There's no way. I have to, 240,000 is not enough.
Yeah, because the fractional part of it. So I guess I'll get into my comments now, which is thank you so much for preparing this. I know it's a ton of work in New Jersey, like it's kind of a diabolical situation with traffic something, but like meets all this criteria. I am like a diehard pro housing person and I live in Frenchtown. I love Frenchtown, but I want more Frenchtownians. And we have this huge deficit of housing, like, you know, nationwide. But Frenchtown also specifically, on average, added 2 houses per year from 1990 to 2020. And we added a lot from 2020 to the present day comparatively, but by comparison, New Jersey grew 150% in terms of housing units per municipality from 1950 to 2020. Frenchtown grew 35%. So for our town, the challenge is like the tax base is not growing, even though the costs increase. And the school population is not keeping pace with population. We have, you know, many single digit class sizes, if not like, you know, 3-person class sizes in the elementary school, et cetera. So having more people in town is a good thing, both market rate and affordable across the board. I personally, I'm a builder, and so I'm very familiar with the economics of like building, have lots of friends in the development world. And specifically like, you know, people who build in the area and the like anecdotal challenge I've heard from them in building in Frenchtown is that it's the same cost to build there as it is anywhere else. But the actual like ROI on the building is not the same as it is in a lot of other places. So there's already like a headwind against development in here. And so when I look at the housing plan, I look at it from the perspective of like, if we do want to increase housing supply, how do we make that as simple as possible for people to comply with? In addition to the fact that there's all the like affordability specific things that are like challenging with housing law. So just looking through this like really quickly, and I think that the echo cottages is a great idea. And I did some research into this. I had not heard it before, because we work in municipalities that have ADU ordinances. And so an echo is like a very specific carve out for an ADU versus a more generalized ADU ordinance. And I think this is like a great time to consider a more generalized ADU ordinance. For instance, in Princeton, the revenue for a lot of the ADUs goes towards the Affordable Housing Trust Fund and unlocks a lot of development potential in the town that can be both market rate and affordable. The issue I've seen with the echo cottages is lack of implementation. Pennsylvania, the largest county to implement an echo program in Pennsylvania, built barely a dozen cottages in 7 years. And we're trying to build 4 of them, you know, for this next round of obligation, which I think is very ambitious. So I would, you know, personally would love to see a carve out for accessory dwellings that's far more permissive. And then also would actually go in more of the R1 sites, because I think it's less than 50% of R1 lots meet the minimum lot size. You know, again, it's an older town. We have very few properties that actually conform to the zoning as it exists now. So whatever we can do to make that not call for a variance and meet the criteria, if the point is to create acceptable housing for in place, et cetera. Then we could, you know, talk with people like property tax abatement, property tax abatement, other things like that, to make it more affordable. The in lieu fee is challenging. I don't like, is that a legal requirement to have an in lieu fee?
It's not a legal requirement, but if, I would tell you in a lot of my towns, you don't pay an in lieu fee, you round up. So if you generate 4.1 units, you're building us 5, which most developers do not like because that impacts their bottom line. So that's why some towns.
I mean, I think that runs both ways and impacts the bottom line when they have to build an affordable unit in place with the market unit as well. And the challenge, I think, for like, for instance, with the shale grit is the like the portion of affordable that needs to be built there for the project to like pencil out. And that's what I hear from a lot of developers, and like, we're just not going to like build something because with these restrictions on top of it, so the more permissive we make the zoning, in my opinion, like the more likely it is that one thing will get like through this pipeline. And And so I think the big opportunity is in like R3 zone, as you pointed out, and I think that's awesome that it's like coming down in terms of minimum lot size. From the 2 acres. That does still leave 3 of the 8 lots in R3 below the minimum lot size. For this, to them not having to do site plan approval to build there. And so, yeah, I guess that's my general point is like, I think this is a great opportunity to see how we can make this the most effective from both a market perspective, as well as like a holistic perspective for the town's benefit. Realizing that you also have to meet the obligations of the law and what it requires as well, so.
Thank you very much for your comments. Appreciate that. Yes, sir.
My name is David Yates, 745 Kingwood.
Sir, can you please raise your right hand? Do you swear or affirm the testimony you're about to give before this board will be the truth, the whole truth, nothing but the truth, so help you God? Thank you. Thank you.
So, my question is more towards implementation as opposed to kind of like the goals that are being set in the plan. And so my question was, how far does the plan go as far as actually setting out implementation? My focus is on the funds that are available for residents to rehab existing properties, because I'm pretty sure they're going to be families that qualify or single occupants that qualify. But they don't know even if it's available, how to access it. And even if they do, they're going to need somebody to help them access it. And it's not like, I'm sure it's not like a grant writer or anything like that, but somebody just kind of walked them along to gain access to those funds. So I was curious, in your thinking, we adopt the plan, do we also, as part of that, focus on how do we actually implement it and provide that kind of detail, which is brought into the plan, or is that like a next step?
So the amended Fair Housing Act has steps in it. So we have to submit this plan to the program. And then there is a 60-day challenge window where anyone can challenge our plan. And then when that period is over, if we have no challenges, it will go to the program for review. We will not be required to adopt any of our ordinances until we know the plan has been approved by the program. It's envisioned that the ordinances would then be adopted by March of 2026. So unfortunately, implementation has to wait until we know that we've received the stamp of approval from the program. Once we do, then, for example, an administrative agent would be retained for the rehab program. They would prepare the applications. That's when everything would start to go on the borough website. It would start being posted that the program's available. And that's part of also the administrative agent's job is when people submit the preliminary application, then they will help them fill out the full application to prove that they do meet the income qualifications and they're not hiding assets. So unfortunately, some of these things were stuck until we know that the program has signed off on them.
But it is actually outlined in here, if I recall, and I cannot tell you what page because you wrote
Well, there
it.
is
I
an
didn't.
implementation.
But there's a whole implementation
At the end.
schedule where it's going to be advertised on the borough website and mailed out with borough mailings, and there's going to be outreach to community leaders and faith leaders and different folks to make sure that they can reach out to folks in the community that might be able to benefit from this. So there is,
If it's county dollars too, there's somebody at the county.
yeah,
administrative.
so that's actually in here. So it's not going to be this mysterious program that, sits underneath a pot up in the office that nobody knows about. This does get advertised in an entirely different way, really, than the affordable housing units are. So there will be a lot of outreach involved in the rehab.
As a follow-up, would there be opportunities for people in the community to get involved in that? So I understand and applaud that there's implementation and outreach plans and the administrative agent, et cetera. But, we're in a small town and there's some people that they're not going to want to take that step. So would there be like a Frenchtown liaison that would actually be your neighbor and that could go in and say, hey, it looks like you might need a new roof. I think I can help you, and here's how I can help you assess this program. and I'm your neighbor, as opposed to, well, contact this administrative agent and somebody will, you know. So that's what I was kind of driving at was, are there gonna be opportunities for community members to get involved? And does it have to be provided for in this plan or not? Right? Am I just
We,
like,
we won't have to mention that in the plan.
yeah,
But I think this is part of the outreach, this in here, where we're gonna reach out to community leaders and reach out to some of the faith leaders in the community and that sort of thing. So it will be, you know, neighbors helping neighbors understand that this program exists. Not a flyer saying, click on this link. You know, which isn't going to work for a lot of the people that need that sort of help, yeah.
That's like, and you may need somebody to sit there and go, okay, well, here's how you click the link.
And honestly, we have, I mean, we're gonna have an update from it a little bit in the meeting, but we actually have a aging in place committee. Which is just really sort of getting kicked off and, you know, and they may manage to work in tandem to a certain extent with this to help make sure that that sort of outreach is made so that we do connect with people in the community. Because you're right, some of the people that need the most help in some of those respects are the least likely to take action to try to get that help.
I
Yeah.
appreciate it. I know we made the point, there's a lot of interest. I know I'm interested in trying to make sure that the stuff that we have here, if there's an opportunity to rehabilitate it and help satisfy the requirement. It's just a matter of somebody holding somebody else's hand in order to walk them through the process. I think there are a lot of people in town that would be able and willing to do that.
Yeah,
Great.
I mean, there's nothing that stops you, right?
Right.
Like,
Yeah.
If you're here and you're interested, like with the echo units, I've already mentioned to some of my neighbors that like, hey, this is coming down the pipe, right? It's a thing that you can just let people know that this is maybe gonna happen. We don't know exactly, but something to watch out for.
Good point, Ted. Thank you very much. Anything else? Anyone else? No? Do I then entertain a motion to close the?
Yes, you do.
I'll move it.
Thank you, Jean. Is there a second? Thank you, Minute. There's no further comment here. Could I have a vote, please?
Doc-
I'm sorry, go ahead.
No, go ahead, Steve.
No.
And we're specifically voting on the resolution.
No, we're voting to
Oh,
close the
just
public hearing.
Okay, you need to, okay.
Need to
Thank
close the
you.
public hearing first.
Okay,
Dougherty,
Yes.
Herb,
yeah.
Howard,
Yes.
Meyer,
Yes.
Redding,
Yes.
Branson,
Yes.
Stenbacher,
Yes.
Echo.
Yes.
Now, if you wish, it would be a motion to adopt the plan, housing element of fair share plan as drafted and to endorse the resolution that has been prepared by the borough attorney.
I'll make that motion.
And the amendments that were noted on the record.
Yeah,
Thank you.
that were not substantial in nature.
Thank you.
Yes.
I'll make the motion.
Thank you, Jean. Now, is there a second to that?
I'll second.
Second. Thank you, Brad. No further comments. Could we have a vote, please?
Dougherty,
Yes.
Herb,
Yes.
Howard.
Yes.
Meyer,
Yes.
Redding,
Yes.
Branson.
Yes.
Stenbacher.
Yes.
Echo.
Yes. All right, very good. Let's keep plowing through this agenda. Amazing work, by the way.
Yeah,
Another round of applause there for darling.
thanks, you did a terrific job. I know you had a team behind you, so
Yes.
please convey our thanks to your team.
My team will be coming here tomorrow with hot copies for Sam.
I thought you were about to say hot coffee for Sam, but yes, hot coffee. Copies.
As amended, not substantial, referred to those spelling errors. and
Yes.
Which
Yeah.
you're gonna.
That will get corrected.
Yes, and then,
Bright and early tomorrow morning.
and they thanks to all the people that helped to put it together to get us here. So wonderful. All right, let's keep moving forward here. We're up to resolutions. We have the resolution for the Dykeman. Which I swore we'd already done.
I sort of did it too. There's some corrections on the last page.
Yeah,
Things that were supposed to be amended, and I think clerk was saying they were amended, except one. Is that true?
He asked for the two additional conditions, which I included as a red line version, which is I'm
Go
sorry.
ahead, go ahead.
Compliance with the board engineer's review correspondence marked exhibit B1 as clarified during the testimony. And same thing, C, compliance with the board planner's review correspondence marked exhibit B2 as clarified during the testimony, and re-lettering everything else. And I submitted that in red line version this
Yes.
afternoon. And I also received an email from Mr. DeSapio that they do not have any concerns with the revised resolution and did not plan to appear this evening. And request that it be adopted as drafted.
Is
Need
there
a
a motion?
motion? I'll move to
Jean?
pass this resolution.
Is there a second?
Amended resolution.
Somebody, who was that, Martin? There's no further questions or discussion on this. Could we have a vote, please?
Dougherty,
Yes.
Herb,
Yes.
Howard,
Yes.
Meyer,
Abstain.
Redding,
Yes.
Yeah.
Branson, Stenbacher,
Yes.
Eckel.
Yes. We already adopted the housing element and fair share plan for round 4, which was down there. So that was that. We already did that. Moving forward to the temporary sign regulation. Let me give a very short history of this. And I know I mentioned this at one of our previous board meetings. And unfortunately, this came at the same time that Darlene's office was creating affordable housing plans for every municipality this side of the Delaware River. So some of our businesses in Frenchtown are really struggling because after the bridge between here and Milford was out, right after that got fixed, we closed the one to Pennsylvania. So they have they suggested a little bit better signage that actually complied with our sign ordinance, because it has turned a little bit into the Wild West out there. We've got a lot of sandwich boards out there that aren't actually legal the way our ordinance is written. So what we're trying to do here is come up with a fix to the sign ordinance. We have been trying to do a full review of the sign ordinance for many, many years, and I would like to use this as a kickstart to redo the whole thing. But in the meantime, we're trying to create some help with the signage to help our businesses. And this is what they put together. This is to allow both directory sandwich boards that help people know where businesses are, particularly the ones that are maybe around the corner a little bit, that aren't on the main drag, because people aren't seeing them. As well as directory ground signs for the businesses. And I have a few edits on this, but the businesses in town, such as the Frenchtown Market, which is not visible from Harrison Street and has precious little signage on it. But really any of the approved businesses that are in the because we have scattered businesses in the residential district, but you drive down Harrison Street and no one has any idea that they're there. So we're trying to come up with a consistent approved system so that they can have some signage. And this is what the office came up with.
Who came up with it?
Darlene's
Okay.
office
Yeah, not
wrote this.
Darlene can't write anything.
No, Darlene's office came up with this. I don't know who came up with it, someone from Darlene's office. But really with direction from, me and Michelle and Brad, we've had some conversations about this. The changes that I had to this was to make it consistent with what we currently have for a sign ordinance, is that the directory sandwich boards shall be made of durable wood or wood-like material. We try not to use the word plastic in Frenchtown. It makes us twitch. So
Composite.
wood-like, there we go. And under the directory ground signs,
Said would like.
wood or wood-like. And then in areas E6 here, in areas with non-residential uses, ground signs providing a directory of approved businesses on the block. So if, in case somebody just decides to, set up an unapproved business in the middle of a residential district, that's not a thing. So I think I'd run this past you as well, had I not? I've been talking to various people about this, but it was, in the throes of affordable housing. We were doing a lot of things at once. And we are trying to get this moved through as quickly as possible. Albert Cruz, who's the borough attorney, recommended, because we tried to run it through Albert a little bit, and he was like, no, it should really come through the planner, and the planning board should recommend it to council, which point council can introduce it. And then this still would not be adopted by council until,
Perhaps get on the June agenda.
do you have a special meeting in June? No,
I don't think so.
so it wouldn't be till July.
Yeah.
Because some of our businesses are really struggling, and we are going to lose some of our businesses if they cannot pick up their business here a little bit.
Yeah, we're in a pretty serious situation with some of our small businesses, including our grocery store.
Yeah, and I don't know if I know some people were on the planning board back then, a few of us, well, maybe me and John, and maybe Brad, actually, but it was, getting a small grocery to move into that grocery space when the A&P closed was a years-long process. And that was brutal, trying to find someone that would come in there.
So I just had a couple questions.
Yeah.
So we're calling this a temporary emergency sign regulation.
Yep.
So does the word emergency carry anything? Like I know what emergency means when there's an emergency declaration, right?
This was sort
Does
of
this
like, this
mean
is sort of
anything?
like when we had the emergency during COVID and we suddenly allowed all the restaurants to set up outdoor shopping venues when we,
Okay.
and this is temporary so that when I am really hoping this will kickstart, and I wasn't going to try to form the committee tonight, a committee to finally look at our very complicated sign ordinance and make it more practical. We've had several stabs at that, which have not been successful.
So the thought is that it's temporary because the emergency is that the bridge is closed.
The emergency is the bridge is closed, and by the time the bridge is back open,
Then people will
we
be
should
flowing
have-
through and buying in all our stores.
we should have a permanent new sign ordinance ready to recommend, which may or may not incorporate these same items as permanent items.
So,
I'm not
so
seeing the
do
word
we,
emergency in the ordinance.
it's in the, under new business though.
That might be the head.
Right,
yes.
The word emergency isn't.
Right.
It's not in the actual ordinance.
Yeah.
But
No,
so
it's
how do
not.
we then define temporary?
big
Like say
word.
we all drop dead tomorrow.
I don't know
How
what
is it
you
that
got
we
in these
convey
sections.
to the next members of the board that this is
Well,
gonna
during
get?
COVID, we said like 6-month time period, so maybe
Okay.
I would just take it through 12/31. Because the
I'm
bridge
okay
will be
with that.
done sometime in December is what we're told.
Let's give us a little more time to do that new sign ordinance.
Okay,
Yeah, let's give us maybe 9 months. I can tell you, I haven't taken a stab at this before. It is, the sign ordinance is longer than most sections, I swear to God, in our ordinance. And it needs work.
Okay, and then my other question was, and this is just me, like, sort of not understanding something. If there's these ground signs.
Yes.
Like, they have to go on the property of the business, right? Like, people aren't putting signs on my
So,
property.
For example, no, I think, and I,
Good question.
B4 actually says that, right? You can't advertise or publicize any activity, business, product, or service not conducted on the premises upon which such sign is maintained.
so,
But it also says that you can put them on Harrison and Milford.
Right, and,
Yeah, so
Right.
that's a
Yeah.
kind of a number.
so we should add, with the property owner's permission.
Yeah. that would be
written
much better.
permission, express.
Oh, yeah, I think there would have to
permission.
be express
Does that
written
include
permission,
renters or just property owners?
property owners.
Yeah.
Can we shove that in there somewhere?
But that would
I'm
also
sorry,
mean that you
which,
can't say yard sign
With the
on
express
the block.
written
Right, right.
permission.
You mean like yard sale?
Oh, we
Yeah,
can talk about.
yeah, sorry.
But
yard
you,
sale.
yeah, so I think people just do, you know what I mean?
Yeah.
And then just that it's over and they
On
take it
Harrison
down
Street,
or
Mill Street.
somebody else
or-
takes it down,
Right,
you know?
Yeah, I get really.
Along
I
Harrison
don't like
Avenue
selective
With
input.
the express written permission. All right, so we're gonna put it up under E6. We'll extend that sentence, maybe placed at corner locations along Harrison Milford Streets with the express written permission of the property owners.
And then my other comment was, this,
Good catch.
I have to say, does sort of elevate my blood pressure a little bit because it makes me very worried, like I have this vision of all these sandwich boards and things around and
They're already there.
yes, well, but that and those cause me great concern in terms of accessibility.
Mhm.
And the walkability.
Yep.
So I don't quite understand how that gets factored in here. Does the
That's tough because
zoning
some
officer get to say you gotta move this over here so someone can get
some of our
by?
sidewalks are so skinny that
Yeah.
you just have to, it's like number 5 says it shall be located outside the street right of way.
Right.
Well, how can you do that when the sidewalk's 4 feet wide?
I know.
And, so I don't know how much
When what if you have a walker or a wheelchair
It's just the corner where you
or
can't
a
put it,
cane?
right? If you can't put
You-
it outside the street right of way,
Say again?
if you can't put it outside the street right of way on that corner, then.
You can't have it.
Right,
Yeah, I don't know. Is the right of way up on the sidewalk, right?
So in one of my towns, similar, old borough like yours, we said that you could not have a sandwich board unless you had 3 feet of clear sidewalk.
I like that.
And then we weren't, then it wasn't about where's the right of way, where's the this.
And with the 3 feet, did that?
Now,
come
it
from
it is
some
an enforcement, your
standard?
point, Jean,
Right.
an enforcement nightmare.
Right,
Yeah.
But
right.
let's add that. Let's add that.
This is with the approval of the planning board. The
No,
7 says with the approval of the planning board. Well, yeah,
7?
temporary off premises directional signs to direct
All the way to the top, all the way to the top.
or the like may be erected only with the approval of the planning board.
That's the existing ordinance, which is interesting because we turned that over to, we turned that over to the zoning officer.
Yeah, let's fix that.
But you turn that, you're adding subsection
Right.
D, which falls within that category of
So
approval of the planning board.
the more I think about this,
Yeah,
that I think this should be a separate section, because if you want them to be temporary emergency regulations.
Yeah.
I don't know if it's our best idea to commingle it in
Oh, that's
Okay.
good,
with
yeah.
Good thought.
the other,
I agree.
I almost would like it to be like a 1-page handout, like here
Right.
are the temporary sign regulations.
Yes, but how do we put that? How do we do that? Legally.
We just add another section to wherever this is in the code.
Especially with a date coming, right?
Yeah.
Say for under the date,
It's under signs and graphics.
Right, so we just add a
Now,
temporary
under-
emergency.
a new section under,
302.
So instead of having it under 7, we just have. We take everything from here down
And make it a standalone.
and make it a standalone.
I think you make it whatever, I don't know if there's a C where it says signs and graphics be prohibited signs, there might be a C. or
Signs and
D.
graphics.
C or D would be temporary emergency signage or something like that, and a new section, and that can be repealed at any time, separate from your.
Overall
regular-
effort. Okay,
But I don't know what the ordinance says in terms of the other sections there.
I'm already. at
and I
page
didn't bring it to me.
I,
I don't think.
It's really long.
Store owners are gonna do this, but do we ask them to take them in at night? And put them
Oh,
in,
yeah.
and put them,
That's a good point.
but they won't do it, but do we put it in there that they have to take?
Okay,
them
so
in?
let's do so J. So we're gonna turn this into J. We're gonna have 3 feet
Clear.
clearance. So when I broke my leg, I went around this town and walked, it was not fun.
Yeah,
We'll
add in something about express written permission from.
yes, we've got the express written permission.
I just gotta go back to.
The time frame, 9 months, right?
The chair said she needs a little longer on that.
Yeah, let's go with 9 months
9 months ago.
Okay.
from the, I mean, I was gonna go with a year, but 9 months is fine.
We'll birth a new sign.
Huh?
Birth a new sign.
Oh, my goodness,
Right.
yes.
Gestation period.
Gestation
And
period,
then
yeah.
John's comment about taking them in at night, which seems kind of
Why,
reasonable.
why are they taking them at night?
That should be.
Oh, just cause, just get them out of the way.
Yeah.
There's no business there.
I'm sorry, Randy, what did we decide about?
Anyway.
this? We
said
delete
that.
this one and say that.
And this may be a wacky question. What
No, we're
about,
gonna
like,
keep it, and no interfere with the safe flow of pedestrian and vehicle
Yeah,
traffic,
that's in there.
in other words, if I put a stake. in the
providing a
ground
minimum
in my
of 3
property
foot
that's away
clearance.
From the sidewalk and then have an
Oh,
L
good.
shape, right? and hang the sign down from that, but it's more than 7, the bottom of the sign is 7 feet tall, will that not be seen? Is that too high? Like that, think about, like, I don't know, but to avoid sidewalk issues whatsoever, right? I'm on Harrison Street, I agree to put a flagpole on my front yard.
I agree.
That then hangs a sign down.
Walking down
And I'm
through
not-
Freehold with my buddy Marty, and he walked in the side of the sign and had stitches. So, because there wasn't a minimum height, so it's kind of a legit thing.
You know, make it 7 feet or something, I think I haven't seen many 7-footers in Frenchtown.
Yeah.
I don't know if we can, if that would be useful or not as a sign.
I don't think it's a bad
They
idea.
have it limited here to 6 feet high. I think.
Right.
No, I'm
What he's
talking about
is
minimum height of a hanging
the
sign.
hang.
Oh, well, we're not even gonna go into the minimum hang, yeah, that's when we start redoing the whole ordinance.
Right, right.
Yeah, I mean, there's a
We do
lot
have
of,
something about that.
we do, there's a minimum height and they have to be secured, there's all kinds of stuff.
When you look at the sign list, I think that is in.
Does that cover the 7E10? Where it says they can be 6 feet high?
Maybe two-sided and not exceed 3 feet wide by 6 feet high and 18 square feet of total area. These are the ground signs.
So a ground sign is, I don't know what a ground sign is.
Yeah,
Ground signs will sound that you're sticking in the ground that have the, you know.
Yeah. Not squared off.
Okay.
I mean,
Good.
it's a good question, but it does sound like it's for the bigger,
Yeah.
the larger effort.
All right, so what we've got so far, this is gonna be standalone and it's gonna be titled
It's gonna be new subsection J. I'm not really sure. Temporary emergency signs, probably.
temporary emergency sign regulations shall be effective.
Oh, that's Steve.
Yeah, yeah.
I think the signs are
Shall be
emergencies.
effective for 9 months commencing the date of the adoption. So it's gonna be standalone, so we'll say that it's temporary and give 9 months. We've changed plastic to wood-like. Under D5, no directory boards shall be located so as to interfere with the safe flow of pedestrian and or vehicle traffic and shall provide a minimum of 3-foot clearance. Directory ground signs, for approved businesses. And they can be placed at corner locations along Harrison and Milford Streets with the express written approval of the property owners. What else did we add?
Do you want to take a minute, Nate?
Do you want to take,
Directory sandwich.
you want to put the sandwich boards in at night?
Yeah,
Hey.
I think so.
Sure,
Yeah.
why not?
All right, directory sandwich boards shall be brought indoors at night. Or during inclement weather.
Well, you're allowing them to be illuminated.
Sandwich boards.
But only in accordance with the rest of the.
Yes, or in inclement weather. Yeah, because we don't need sandwich boards blowing through town.
Yeah, actually, that's just portable sign.
Right.
That would be in directory ground
We're not
signs
considering
are portable, but they can be illuminated.
Nice.
Went from $300-400 a month to.
So sorry for putting this all on you tonight when we already had affordable housing, which we're up to our ears in. But is everyone good with this? Could we have a vote to recommend this to council as amended? So that we can get this going, so that maybe we still have a grocery store a year from now?
Second.
That was John Doherty, seconded by Brad. Any further comments? Hearing none, could I have a vote, please?
Doherty,
Yes.
Bird,
Yes.
Howard,
Yes.
Meyer.
Yes.
Redding,
Yes.
Brinkman,
Yes.
Stenblicker,
Yes.
Eckel.
Yes. Wonderful. So we need to,
Information. Can we get this on our agenda for next Wednesday? Do we have time or does it?
yes, you shall have it on your agenda for next Wednesday.
Get a copy of
Yes,
it.
Darlene, you're gonna be.
I'm going home and writing a house.
Move from your
Can you-
office then.
Can you,
Otherwise-
That's an
Darling,
excellent question.
Otherwise, we're gonna have to ask.
send me what you just had.
Yeah, okay.
I will draft it.
Okay.
Okay.
She needs a promotion.
Because I can take her notes, which were beautiful, because I saw her writing them.
Huh.
And I will draft it, and I might get Steve to help me just to touch on that,
Okay.
That's a good idea.
okay? Because yeah,
They've got
they're
great ideas.
up to their ears. All right, wonderful. Why did I just volunteer to do something? All right, moving on quickly. Affordable Housing Committee update. I don't think we really need an update on the Affordable Housing Committee tonight.
I think we got
I think
it.
we got that. Aging in Place Committee update.
The borough's grant was approved from, on the SAGE system, but we haven't gotten the letter of whatever you call it, funding yet. And so we kind of are feeling a little bit like, so, Brad, if you're okay with it, I wouldn't mind playing bad cop to Sam's good cop with the state.
Okay.
At the letter, okay, thank you.
Yep, I can do that.
Okay.
I also think we should begin some of there's a lot of work we can do, a lot of steps we can take that don't require any funding, money, hiring or anything. And, you know, I said some around some, what's going on in other similar communities, what services are available. I guess I can volunteer to start putting together some plans to get us actually moving.
Have you tracked down an ordinance for?
Yeah, I think I sent some ordinances from some other places as well. I'll take a
Okay.
look through. If I have-
I'll take a look to see if I got it from you.
Yeah. if not,
I just want to be
send that
cautious that
around.
we're not solving problems that aren't identified by the people who live
Right.
here. So listening
But,
is the
yeah,
first step.
listening
No,
was
I
the first step,
understand. That
but this
issue's
is one
been
we've already
chronic.
heard.
I get that one's chronic.
That's
Yeah,
one.
Solution in search of.
But
a
I'm
problem.
certainly we will be hearing about how hard it is to get into town with all these signs now.
But they're already there.
I'm just saying.
They're already there. This is giving us an ability to,
The first thing we need to
Manage
do.
them.
That's right, get rid of
Get
those
rid
signs.
of the
Okay,
signs.
so that's where we're at, but
moving on.
I'll make a motion to
The
approve the
vouchers.
vouchers.
second them up.
Thank you. If there's no comments on the vouchers, could I have a vote, please?
Dougherty?
Yeah.
Herb?
Yes.
Howard?
Yes.
Meyer?
Yes.
Redding?
Yes.
Branson?
Yes.
Stenblicker?
Yes.
Eckel?
Yes. Correspondence, council representative report and other related items, compliance review for Doug Stryker. I need guidance on this. We have things that they haven't done. What are we supposed to do about this? Was this just given to us for information? We have conditions that aren't satisfied all over the place.
I have to admit, I did not read Bob's letter, but there's a few shortcomings. They just need to submit revised plans.
Okay, so we need to, because Bob had several things on his as well. Do we need to? I don't remember actually getting a compliance review where somebody hadn't jumped through all the hoops and done what they were supposed to do. So I'm not quite sure what the process is here. Who chases them down?
They
For
get a copy
compliance.
of the letter, and if they want to build, they have to come do the compliance in order to secure building permit.
Okay, so
It's
we,
nothing really that the board needs to do other than you received it as a communication.
okay, very good. That was what I was hoping you were going to say. Good. It's like, but we don't take action under
I
correspondence things.
spoke
really.
that generically since I'm conflicted on that matter.
Oh, yes, of course you did. And just in a general sense, that's what one would do.
Yes.
What have we got for reports from council and the mayor? What do we know?
I'm sorry, I'm drawing a blank right now.
Well, National Night Out, August 9th. We got that. That's
Okay.
gonna happen this year. We just sworn a new patrolman, David.
I saw that.
So that was good. So the third full-time officer. And the other noteworthy thing,
Brad, when's your sidewalk gonna start?
that's a frustrating topic. We still have 5 property owners that have not yet consented to the work along Harrison Street.
Well,
And that is holding up everything. So we're asking the state, Department of Transportation, what we should do, because we're not getting cooperation on, and, I've asked them, can we use eminent domain if we need to, or can we just draw those property out of the project? So they'll have what they have in their house, and not only that,
Interesting.
because it's holding up the entirety of the project. So that's where we're at. That's very frustrating. Because we sent 4 now, right? 4 mailers, certified mail, delivery receipt, et cetera, and we're not getting a response.
Has anyone tried knocking on the door?
Actually, Sam
Yeah.
and Kelly did try that too. So
Wow.
I don't know what more we can do,
Wow.
you know?
Yeah.
Do they not answer?
No, nobody was there. They were just like, okay, thanks. You know what I mean? A lot of the letters we received, they went to the actual property owner and then
These
the
are-
tenant. So it's
There are investor-owned properties, which we're having more and more trouble with across the borough.
Sure.
So it's the owner that has to consent, not the tenant.
Right.
Yes,
Yeah,
Yeah.
so.
that's difficult.
That project was supposed to gonna happen this year. So I gotta see where we're at with DOT. Actually, I sent an email out today to the outside engineer. Asking, can we get together with DOT and ask, what do you do in this situation when you're a small town?
Mhm.
You know, you're gonna have some encroachment on people's lawns while you're working on resetting their pavers. If they don't get back to you, how do you, I don't wanna hold the rest of the town hostage.
Yeah, no, it's fair.
Is there a chance that the money gets rescinded? It's federal money, right?
Right now, we're still good on money, that's good, but, you know, obviously, as the days go on, it obviously makes us more nervous. As
Yeah.
things continue to progress in Washington, so. The only other thing was, we're trying to hire a new DPW director, we've identified 6 candidates, we're gonna start. Doing interviews, and, we got approached by 2 different vendors trying to buy our sewer plant, which is interesting too. But I don't know, that's a pretty complicated process, and I don't know if that's in the best interest of the town or not, but.
Well, they buy it and then lease it back, or is that how that would work?
They
or-
buy and own it, and then they operate it as their
Right.
own utility.
Yeah.
So New
Interesting.
Jersey American Water reached out as well as, Viola.
Mhm.
something like that.
Would we have to create a utilities?
I don't know enough about it. I gotta let the council know that we got this piece of the correspondence.
Yeah, it's worth looking into, right?
Yeah.
I mean, in terms of part-time personnel, our cost for it. I mean, in a sense, it comes down to a pretty simple equation. If they can do the work and which is less expensive, right?
Yeah, I think it's also, we have to look at, we have federal and state monies that came to us
Right.
in the form of grant and loan programs, and I don't know how that works. I'm assuming you have to satisfy those first, those
Yeah.
programs.
And you also don't wanna lose control of it.
Yeah, that can be different too.
Yeah.
But some communities are beginning to get out of the business because it's gotten more complicated. And particularly smaller towns, so. Anyway, we got this correspondence, so I'm gonna share that with the council as well, but. we'll see what happens.
And look at the financial
Yeah.
ups and downs and.
Yeah,
Yeah, just from a,
Problems there.
business operations, obviously, a giant corporation that, manages 50 plants should be able to do each one for a heck of a lot less money than a small town.
I don't know if that's necessarily the case. That's,
What's
a-
that?
Yeah,
that's an
they're also,
assumption. I
they're
don't
also
think-
gonna be able to charge whatever they wanna charge.
Yeah,
Well, no, because we don't have to say yes, right? I mean, it's a negotiation.
right, but I wouldn't
process.
assume that.
It's interesting.
Highbridge has been faced with similar things in the past, their voters did vote it down.
Yeah.
So, interesting concept. I'm sure you're very familiar with that.
Thank you.
Familiar with that. Wooden pipes.
So, yeah,
So those are the big updates.
Thank you.
all right, if there's nothing else.
I'll make a motion to adjourn.
I'll second. That was quick.
All in favor of adjourning, say aye.
Aye.